And then it's so far, like an hour cooling down. Yeah. Can't do that anymore. So far, I mean, I feel like you need solidify that. Yeah, just so the jury gets spectacle first, because otherwise they're going to get. And they'll have already heard.
Does it have legal or?
I mean, I think he's gonna be a stickler for here. He's, and if we want to make more come back to the church. Yeah, we could directly. 28th of January, so very soon. Again, it was notified after the talk. Oh, yeah. I'm sorry, I have a way. I think it's one. Oh, it is. Other
All right, everyone, quiet, please. So I'm going to call the docket. If you're here, let me know you are here. I'm being told that today is Wednesday, so we're already into the middle of the week without having a Monday at work. April Ramirez. Oh, we're not starting off great, are we? April Gonzalez.
I believe that's
The same person, yeah. In jail, we have Rogelio Sanchez, Jesus Solis, Isaiah Sampson.
I'm here for Isaiah Sampson.
Thank you. Yes, thank you. And custody is Arturo Contreras.
I'm here for Isaiah.
Thank you. Guillermo Lozano. Douglas Hughes.
Your Honor.
Fabian Cardenas. Okay. Patricia Lopez. Jose Corona. James Lopez. Brandon Castillo. In custody, we have Gregorio Cantu. Carola Amador.
President, council's present.
Where's your client?
I believe she's out in the hallway. I'm going to walk up there.
She needs to be in the courtroom. Victor Ramirez Acosta. Christopher Armstrong. Patricia Lopez. James Brooks. Wardell Lemon.
Your Honor, he's in line in security. He should be up front.
All right, thank you.
And Mr. Nettles is probably with him.
All right, thank you. Renee Espinosa.
Sure.
Jose Perez.
Sure.
Santuan Wilson. And Melvin Jones.
I'm just waiting on Miss Harrison.
All right, thank you. All right, anyone who came in late? Yes, what's your name?
Juan Martin.
Do you have an attorney?
Yes.
Who's your attorney?
Can't pronounce the name. I think it's Martha Chacon.
Meredith Chacon, I'm guessing.
Oh, all right, thank you. All right, just give us a moment. Anyone else? All right, everyone, we have a jury trial that's going to start up, so please confer. Just grab your file, place it on the prosecutor's desk. They will call you in order of appearance. And if you have someone who's in back, the deputies will bring them out, which I think they've already brought them out. So everyone, please confer and be kind. Thank you. Yes. Yeah, it doesn't necessarily have to be real time because I know there's a shortage. So just whoever you can get.
So maybe I just let the judge know that she may not.
Okay, all right. Good morning. Yes. Mhm. Okay, you need to have the clerk put the file and we'll go on the record. Thank you. Oh, yeah. The rain. Yeah, rain makes flowers grow, so it's great. We need rain.
Yeah, no problem.
Deputy. Go to the 227th and see if the people who are supposed to be here are down there.
I called out and then. School again, maybe.
All right, thank you. Thanks, guys. Deputy Laura, I knew you were on it.
Which one is that? This is. April Ramirez.
All right. Does anybody know why is there Cynthia Vasquez in the?
Oh.
Yes, okay, all right, thank you. Good morning, and where is Mr. Brooks? Okay,
The first one for probation. Yes.
Not be guilty for doing it. Yeah, yeah. Girl.
Yeah.
It's fine. Oh, that's. Yeah.
Yes, how are you?
Good, Bryce Morales. This is actually Denise Pearson as a prosecutor. She's not here today, but
Okay.
I guess you can look for setting, if you wanna.
Yeah, yeah.
All right, thank you.
Need to contact them, but talk to you about offers.
I didn't talk to them. Raul, yeah. He's a cool guy, very, very. So, Everybody likes it.
All right, are the parties ready on Melvin Jones?
Oh, he's here.
See in the middle?
Hi.
Morning.
Morning.
Morning,
Good morning. Are there any jurors in the courtroom? All right. Court is calling 2020 CR 8810, 2020 CR 11654, 2021 CR 2489, and 2022 CR 8528, State of Texas versus Melvin Jones. Can I have parties announced for the record, please, for the state,
Stacy Harrington.
for the defense?
Robert Porter.
All right, so the last time we were here on an issue of whether or not a plea bargain was issued, whether or not the plea bargain was accepted by the defense. Is that correct?
Yes, Judge.
All right. So have both parties had a chance to do their research? Because I've had a chance to do mine.
We still stand by our position, Judge.
And Judge, if I may, for the state would still assert that an offer was conveyed, a counter offer was made, so that would mean that the defendant basically rejected the state's offer by making that counter offer and not accepting the state's offer.
And Judge, my issue with that is simply this. As the court pointed out just this morning, every one of these defendants in the courtroom today are on a trial setting, which means their offer has I guess their plea offer has expired. Yet the court in herself sat there and said, now y'all go and you can negotiate or please confirm. So that puts a defense at a quandary now, because once an offer is made, are we allowed to confer any further? Not confer in the. For the state sit there and say, well, then are they rejecting it or not? It puts it in a bad position. So we don't. That is why when Mr. Jones sat there and said, I'm not rejecting the offer, we did what we did. And so it's our position that he never rejected the offer.
Okay. And what I can tell everybody, and Mr. Jones, you've been in this court, I give everyone plea deadline dates. And I tell everyone after that plea deadline date has expired, the court will not accept any plea bargaining agreements without good cause. Otherwise, you have to plea open to the court. And when I give my plea deadline date settings, it's not done arbitrarily. I do it bearing in mind the nature of the offense, bearing in mind how much time someone would need to consider. And usually when I set the plea deadline dates, I'll ask defense counsel, how much time do you think your client needs? And sometimes he or she will confer with their client and say, oh, well, we only need 2 weeks or we need 3 weeks. And usually when they ask for 2 weeks, sometimes I'll go along with the 2 weeks and sometimes I'll give them more than 2 weeks just based upon the nature of the case and other things that I objectively see. When we were here last time, I talked about my contracts professor at St. Mary's University, Miss Casterly. And of course, when you're doing plea negotiations with the state, It's a little hard for the court to see anything because these are oral negotiations. You don't have a contract where somebody presents a contract and it's, here we go, this is what we've agreed to. These are the dates we've agreed to for me to enter the plea. But according to all of the case law that I've seen, one, if a plea offer is rejected, or if someone does a counter offer, that means the plea has been rejected because you're doing a counter offer. The other thing is on the criminal side, the defense and the state come together with their plea bargain agreement. And that agreement is not an agreement until the court accepts it. And according to the case law, until the courts accept it, the state can withdraw their plea. Now, I can tell you what the unspoken rules are. The unspoken rules is that if the state makes an offer, everybody is going on the fact that they made the offer. Defense gets a chance to consider it, and the defense gets a chance to say, I accept the offer or I don't accept the offer. And usually the state will honor those offers. They don't yank it back because they say, oh, we haven't gone before the judge yet, so therefore the plea is off the table. But you all, it appears, based upon what was put on the record last time, you all had a plea deadline date yourself outside of the court's plea deadline date. So that was a part of your oral agreement. Then you had an offer and a counter offer. The court can't really go behind plea negotiations that you are doing. Legally, ethically, I'm not allowed to do that. So the state has informed me and informed your counsel that they're withdrawing the plea offer that they previously extended, so it's withdrawn. And I can't force them legally or ethically to put that offer back. Do you understand, Mr. Jones?
Not exactly, because
What part don't you understand?
because what I was going by was when we was here on the 19th of December, that you said that you yourself was saying that my plea deadline date was the 24th of January. And I'm at that time I was having a problem with my attorney, and that when he was telling me the stuff that the DA was saying, it was kind of like a bad.
So
It was like bad language in my ears, and I didn't like what I was hearing because I was already having a problem with my attorney. But at the same time, I'm going with what the judge of this court was saying was the 24th of January was the plea deadline date. So I was feeling like I was being forced to do something that I didn't want to do.
Well, Mr. Jones, here's the situation you're in now. And I'm internalizing everything that you're saying, but according to contract law, if you think the date is something else and the state thinks the date is something else, then there's not a meeting of the minds on the plea agreement. And if there's not a meeting of the minds, then there's not a contract.
So it never was a contract.
No, you're telling me that you thought it was a different date,
Yes.
right?
Yes.
The attorneys are telling me a different date. So what that means is there's not a meeting of the minds. And if there's not a meeting of the minds on what the contract is, on what date the contract is due, then there's no contract. For example, if you're building a house for me and you say, I'm going to break ground, I'm agreeing to build a house for you, but I'm breaking ground on December 24th. All right. And I say, okay, you're breaking ground on December 23rd, right? And you're like, no, the 24th. So I'm waiting around at my house on the 23rd and you're never breaking ground.
Yeah.
In my mind, according to the oral contract that we have, I'm thinking you're breaking ground on the 23rd. So the fact that you're breaking ground on the 24th, we don't have a meeting of the minds on what the contract is. And if you don't have a meeting of the minds, then you don't have a contract.
Yeah.
So you all don't have a contract. Based upon what you're telling me, you didn't have a contract. And if you did think you have a contract, the contract has expired. That's one. So either there wasn't a meeting of the minds, or either the contract has expired, or either you rejected it with the counter offer. So according to all of the case law, the state is permitted to withdraw their plea. And that's just the case law. And you know how this court is, I follow the law. And so there are cases out there, Bexar, I know I'm mispronouncing that, Becerra. That's the rule. So there's no contract. So if you all want to negotiate something else, you're more than welcome to do that. And I will extend, counsel, I'll extend the plea deadline date, since it appears that there's some new negotiation going on. Ms. Ferguson, on Melvin Jones, does he have a court date other than this date that we have here?
No, Your Honor.
Yes, he has a court date for the 24th. The 24th. It's impacted.
All right, so what I'll do is I will extend the plea deadline date to your jury trial date, Mr. Jones.
Sorry, Your Honor, what's that date?
It is your date is the 23rd, but the jury trial will be on the 24th.
Next Tuesday.
Yes.
Impact starts on the 20th.
Oh, I'm sorry. You'll need to be an impact on the 23rd.
Oh, wait, excuse Judge.
Yes.
Thank you, Judge.
No, I have control. Oh, just 1 second. Okay. Arturo Contreras.
Morning, Your Honor.
Good morning. Yes, what is happening with this case?
Yes, Your
And
Honor.
where's your client?
He's right here, Your Honor.
All right,
Your Honor, we're asking for a short reset where this is a 20 count indictment and we're in plea negotiations with the state. And there are also immigration implications in this case.
right, you say a 20 count indictment?
Yes.
All right. So what, you said there are other implications?
There are immigration implications.
All right, does he have an immigration attorney?
No, Your Honor.
Are you appointed? Does he need an immigration attorney appointed to him?
Yes, Your Honor.
All right, Ms. Ferguson, I need an immigration attorney appointed to Contreras.
Second, I can call public defender's office. Give me just a moment.
All right, and I'm gonna need a 30-day reset also.
Yes. I can do February 13th.
All right, and is there any language issues? Will we always need an interpreter or do we need one?
No, Your Honor. There's no issue, no language issue.
All right, so we'll get a immigration attorney appointed.
Hey, Your Honor, will I be receiving notice of that or will it?
Oh, you're gonna get it before you leave court.
Excellent. Thank you, Your Honor.
All right, you can have a seat.
Thank you.
You're welcome. Who's here on Fabian Cardenas? Who's the attorney on Fabian Cardenas? All right, Mr. Cardenas, just have a seat. We're waiting for your attorney. Christopher Armstrong. Hello, what's happening with this case?
I have been given an offer and discussion with my client. And I don't know if you're able to take a view this morning.
Yes. Okay. All right, just get the paperwork.
Let me, I have to ask first.
All right, okay, thank you. Everyone, we're bringing the jury in at 10:30, so everyone needs to move with a purpose and a plan. John Coates. Hello. Oh, I'm doing great. Other than it's 1,000 degrees in the courtroom today. It's not too bad. Well, you're not. I'm wearing sweaters and everything else.
6.
Well, you know what happened to our cold front? That's what they said. They said rain and a cold front.
37 years.
Mhm.
No true word that ever been spoken. They
No.
lie, they're professional liars. They can hang up and there's no risk of no.
Can't do anything. Can't get a refund.
No. You're screwed.
And Norma, if their immigration attorney is going to take like 6 weeks, then we're not using it.
What's that?
I'm sorry, what? Okay, yeah, call Teresa. Let her do it. Okay, well, we'll do Code Solomon. And if you give them the information. Okay. Is the attorney here on Fabian Cardenas? Okay.
That's a scratcher. Yeah, because it just coming after lunch. Then it was another one, but there's someone those boats. Well, because it was. I'm saying, I say.
Patricia Lopez.
All right, thank you.
My bad.
What's going on? Yeah. Any chance?
I thought you
Okay. Even if it's higher number, just.
Yes.
Christopher Armstrong,
He's over there.
he's excited to go to trial on it.
All right, Mr. Armstrong, come forward, please. Who's the prosecutor on Armstrong? It's an unauthorized use.
Jason Jorgens for the state judge.
All right, he's requesting a jury trial. How long do you expect this to last?
Probably 2 days now.
Okay, all right, Ms. Ferguson. Are we able to fit this for jury trial for next week or in 2 weeks? Yeah, it's unauthorized use. All right, so your jury trial is going to be on January 30th. And that will be your plea deadline date. Do you have all the discovery counsel?
Yes, Your Honor.
All right, we'll see you then for your jury trial.
Thank you.
You're welcome. Ms. Ferguson will give you a reset form.
Yes, Your Honor.
Who's here? I'm Patricia Ann Lopez.
Judge, I am, and apparently there's another, I have 2 cases and there's another attorney appointed on another one. But Patricia Lopez is here and she looks really sick. I don't know where she went. There she is. Like sweating and like really sick. And she was wanting to go get a COVID test.
Oh, well, thanks for coming into the
Yeah, I know.
courtroom.
So.
Ms.
I didn't-
Ferguson, can I have a 30-day reset on Lopez?
Thank you, Judge.
All right, February
Thank you,
13th, Ms. Ferguson will give you a reset form.
Thank you so much.
You're welcome. Is the attorney here on Fabian Cardenas? Okay. Jose Corona. All right, where's your client?
Walking through.
Everyone, please keep the middle aisle clear. All right, what's happening with Mr. Corona?
So I spoke with the DA regarding these 2 cases. They informed me that there are 2 other sealed cases that we don't have any knowledge of, and we would like a recess to look into those.
All right, Ms. Ferguson, can I have a regular reset on Jose Corona? All right, February 13th, Ms. Ferguson will give you a reset form.
Thank you, Your Honor.
You're welcome. Who's here on Corolla Amador? All right, where's your client? Have her come forward. All right, what's happening with this case?
Judge, this is our first time we receive an offer from the state. Short reset just to go through the goal to make sure it's the decision.
All right, Ms. Fergus, can I have a 2-week plea deadline date, please, on Amador?
February 2nd.
All right, your plea deadline date will be February 2nd. At that time, you need to let the court know whether or not you're accepting the plea bargaining agreement. If you choose not to accept the agreement, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. All right, they'll give you a reset form and then you're excused.
Thank you, Judge.
You're welcome. Is Brooks here?
James Bexar?
Yes.
Yes, he's sitting over there.
I'll have him come forward.
Yes, Judge.
Thank you. All right, so we didn't address this issue last time because the court was not made aware of this issue. The court was only made aware of this issue after the fact. So because I was made aware of the issue after the fact, I'm just going to admonish you today. Pretrial service officer is connecting to you. You want to explain to me why you were stopping at a gun shop?
Kind of just bored that day, you know, I was just browsing. Like, I'm not planning to like buy anything to understand. I'm not able to have a gun at this moment.
You're on GPS. You're not allowed to just walk around freely and go wherever you want to go. You understand? I'm sorry? What don't you understand?
I didn't really understand that I'm not really able to go into a store like that.
You understand now?
Yes, ma'am.
Right. You're not allowed to do that. You're not allowed to be around guns. You're not allowed to buy guns. You're not allowed to browse for guns. You're not allowed to go on the internet looking at guns. None of that. Do you understand?
Yeah.
Is there anything that you don't understand what you cannot be doing? Are you looking for something? I don't have any up here. Okay. All right. All right. Thank you. So Ms. Vasquez? Ms. Vasquez, you're on mute.
Good morning.
Good morning. So we've already addressed the issue with him going to gun stores to browse. Is there any other place that he has been that you feel he should not have been?
No, ma'am, it was just the gun store.
All right. So you can't do that. If you get bored, read a book. That's what I do. And there are so many good books that are out there to read.
He's going to San Antonio College, Judge, so he needs to crack them books and, you know, work on his
Yes.
schooling as well.
Okay.
He's studying science, so he's, you know, looking forward to that, Judge. And I'm gonna go over with him. I was made aware of the fact of the gun store as well after we spoke, so I apologize about not knowing that.
Oh, no, I didn't know. You didn't know. Nobody knew.
Yeah, so it's one of those things, Judge, but I'm gonna print out his conditions and go with them again and just to the T, because I think he was confused before. He had full house arrest and he didn't know if it changes because of the partial, but I explained to him that just really, you know, he can go to places that he's authorized to go to, kind of thing, and nothing out of the norm, such as, you know, with the store, selling arms and things of that nature. He shouldn't be around those areas, so we're gonna talk about that.
Okay. All right. So we'll see you back on February 7th. Okay. All right, Ms. Vasquez, is there anything else he needs?
No, Judge, he's already reported with me and I've given him another court, or another check-in with me.
All right, thank you.
Thank you.
Thank you for coming in, and
Thank you.
thank you for dressing appropriately for court.
He's looking sharper than myself. Man. I mean,
Yeah.
everything else is from him. Maybe be excused.
Yes. Who's here on Fabian Vega?
I am your honor.
Yes.
Daniel Escobar. Good morning, Judge.
Good morning.
Yes, we're just asking for additional funds for the investigator to help us with the discovery. We got a copious amount of discs in this case.
All right, you didn't put an amount in here. So what are you requesting?
Well, Judge, the exact amount of discs I mailed into the investigator.
It's 38.
Yeah, it's
No, I mean, what amount of you, yeah,
requesting,
you're requesting?
$1,000, Judge.
Okay,
He is set for trial February 21st, Judge, so we're trying to get this,
sure. Is there anything else that you needed?
not today, John, but thank you so much.
All right, you're welcome.
All right.
So I've given 1,500.
All right, Judge, I appreciate that.
You're welcome. If you need something else, just let the court know.
Absolutely. I would just a copy of the order, but I can get that.
Sure. Who's here on Jesus Solis? All right, if you come forward. Good morning. I have this on the docket for January 26th. I don't know why it's here today, but well, we're here. We'll take care of it. All right, so what is happening with Mr. Solis?
I am approaching the court regarding a motion to reinstate bond. He had his case indicted, but there was a miscommunication. This was before I was on the case. He didn't know he had court. He missed court, didn't show up. His bondsman got off the bond. And so I conferred with the state. The state is in agreement to an increase to 20,000 as a sanction. If the court is in agreement to do that.
Okay, and it's my understanding that it's a matter of the bondsman getting off his bond.
Yes, Your Honor.
All right, your court date is January 26th. Do you understand? If you're not here on January 26th, what's going to end up happening is a warrant may be issued for your arrest. And I write everything in the docketing sheet. You understand? You're not responding to me. All right, so when is your court date?
January 26th.
At 9 a.m. this court. All right, thank you.
Thank you, Judge.
Yes.
This case.
All right, thank you. Caroline, could I see the case on Isaiah Sampson? Thank you. Who's here on Brandon Castillo?
I am your honor.
Good morning, Your Honor. Daniel Bell
morning.
On behalf of Mr. Brandon Castillo.
Where's Brandon Castillo? All right, everyone, when you approach with your client, please.
In the middle.
All right, what's happening with this case?
Judge, we conferred, we could not get to an agreement.
All right, was an offer tendered?
Yes.
All right, so how can you guys not come to an agreement and if an offer hasn't even been extended? So y'all need to go back and confer. The state is prepared to make an offer, then the state will make an offer and you need to tender it to your client.
I'll make sure that we're prepared to make an offer today, Judge. There are 2 sealed cases from the
Okay.
incident. So I guess we requested at the time so I can try to look into whether those are gonna get back.
All right, you're gonna come back on February 13th. Just remain in the courtroom and Ms. Ferguson will give you a reset form.
You're on that one. Ms. Benson, good to go back?
I'm sorry?
Mr. Sampson?
Yes. And can you tell me that's February 13th? For Ms. Ferguson. Where is Mr. Sampson? Is he just in the back?
No, Your Honor, he's out here.
All right, so Mr. Sampson, you should be released sometime today. It'll probably be more like midnight. All right. Don't let me see you back anymore. All right. Unless it's to visit. Courtroom is always open. All right, James Lopez. Hello.
He's making his way out.
All right, so what's happening with this case?
Judge, it's a first setting. I'm having IT issues, so I believe the state has all the discovery and I'm just having difficulty getting it. We're asking for a reset. Mr. Lopez's mother passed away. He's trying to get to the services.
Oh, well, why is he here? If his mother has services?
Requirement to be here. We're going to special this afternoon, but I just.
All right, Ms. Ferguson, I need a regular reset on James Lopez.
13th.
All right, so Ms. Ferguson will give you a reset form, then your excuse.
Thank you, Judge.
All right, thank you. Sorry about your mom. Who's here on Rogelio Sanchez? All right, Mr. Sanchez, come forward. Hello, so where are we on this case? Who's the prosecutor on this case? Oh, Mr. Gillihan. All right, so we're here recalled for discovery.
In just bring the court up to speak, Cornelius Scott for the defendant. Last time we were here, there was an announcement. We had a different prosecutor. The state, you can correct me if I'm wrong, indicated that they were not going to seek death penalty.
Oh, yeah, they did that on November 17th. I have it in the document sheet.
So at that point, we received, we have a hard drive. We should have.
And actually, so it's clear, on October 17th, they said they were not seeking the death penalty. And then we put it on the record on November 17th that they were not seeking the death penalty.
We have the hard drive now.
Mhm.
Hopefully, it's going to take us time to go through it thoroughly. Hopefully, we have all the discovery in this case on it. So that's basically where we are. And then the state, I would imagine, is going to sometime in the future make us some type of, we'll get together from some type of offer.
All right, Ms. Ferguson, I want this set in 40 days. In 40 days, what's going to end up happening, state, will you be prepared to make an offer?
Oh, yeah, Judge. I mean,
All right.
I'm familiar with the facts. I've read the case and everything, so I'm a little bit ahead of the game now.
Oh, awesome.
Trying to.
So if I can have a 40-day reset?
Yes, Jason, I don't know if you were gonna supplement any of the discovery or if we had everything.
There may be some supplements, because sometimes I haven't looked through all the discovery at this point, but I've read the case, but I have not looked at everything. And I'm gonna probably check with y'all to see what y'all have in your possession.
Okay.
So, yeah.
All right, so you're coming back on March 3rd. At that time, the state is to make an offer. At that time, I'm expecting everybody to have reviewed whatever discovery. Then once that offer is made, I'm gonna give you another reset date for a plea deadline date, unless you decide to accept the offer on that date. And then after that, we're gonna have a jury trial date. Any other questions? All right, thank you. Are you joining if Mr. Cox is in jury trial today? Are you joining Mr. Cox for jury trial if he's in trial today?
Yes, Your Honor.
See,
That's on the record, right, Judge?
that is on the record. All right, then, Mr., if you all don't need to speak with him, he can be taken back. All right.
Thank you, Judge.
Who's here on Lindsay Pierce?
I am, Your Honor.
All right, what's happening with, where's Pierce?
It's here, Your Honor.
Come forward.
Making sure I got the right one. I'm positive.
Have you conferred with the state on this motion to travel?
We have, Your Honor.
And
We're unable to reach an agreement, Judge. If I'm gonna approach with what the state can agree to, so that I don't continue to repeat myself. We're in agreement that she'd be allowed to go to the Make-A-Wish trip with the complainant. But I believe that we have a disagreement on whether the order subsequent to the return should be no harmful injurious contact, meaning they could have full contact, versus the state's not comfortable with that. And we've offered to agree to something else, which they don't at this point believe in their best interest.
so I believe in crossing bridges as they are built. So the first thing, let's just deal with this Make-A-Wish. And then once we deal with that, then we can come back on a different date because we're going to start up a jury trial for whatever issues.
I believe it was a motion to travel and it was a request to lift the no contact order, Your Honor. We'll defer to you either way, but I'm just letting you know that I guess my question is, do we have to file a subsequent order?
No, you will not.
Or a subsequent motion?
No, you will not.
Okay.
So we're going to deal with it appears that the state is in agreement that you go to the Make-A-Wish. Is that correct, state?
Yes, Judge.
All right, so we'll deal with that because we have a jury trial that's coming in at 10:30. The second part of the motion, if you want to set it when she comes back from that, because honestly, I want to see how that goes. And then that will give me a better idea of the other items you're asking for in your motion.
Thank you, Judge. I believe the state, is also in agreement that they're allowed to have contact for purposes of child exchange and communication about their children. And I just want to make sure that that's also okay with the court, and then we can come back for.
Well, my understanding, this is what you all agreed to. So we're.
No, that they do not wish to agree to that second portion of it.
All right, so the court is saying, let's just go with she can do the Make-A-Wish. And then when she comes back from that, then we can address the other issues, because I'm going to need witnesses here so I can make an informed decision on the no harmful or injurious contact, because the only thing I know about this case is it's a burglary of a habitation with the intent to commit assault. I don't have any facts about the case. That's the only thing I know. I'm assuming this is involving a child. Am I correct?
No,
With
Your Honor.
the no contact is involving an adult.
Yes, the parent of the child.
All right, so I'll need to speak with that person, and there are other witnesses that I'll need here so I can make an informed decision.
So the no contact is lifted for the purposes of travel.
Yes, for this, the Make-A-Wish to Disney World. All right.
And then regarding child exchange, they still need to go through other.
Yes, and if you'll just get a setting from Ms. Ferguson, I will hear that as soon as she comes back from Disney World, or as soon as you want it back after she comes back from Disney World, because it shows here that it's from January 23rd to January 29th.
That is correct, Your Honor.
All right, so if you want to set it for hearing immediately thereafter, the court will hear it, and you do not have to file another motion.
Would it please the court if we just agree with the state on this and then file a motion when we get back? Because the state is okay with contact. If we're okay, no.
You're not agreed to this? My understanding that the only thing that's being agreed to today is that she can do the Make-A-Wish. Am I wrong with that?
Yes. So what I put on there is that upon return, that is what it is, because the trip I understand is next week.
Okay. Thank you, Judge. And I apologize for my confusion.
Oh, no problem. So my understanding is the state is in agreement for her to travel to Disney World. But the orders will be reinstated once they arrive back. And when they arrive back, if you'll speak with Ms. Ferguson before you leave here today, we can immediately put it on the docket for the court to hear it, and I'll expect the complainant to be present.
Thank you.
All right.
May we be excused?
Yes, if you want to get a date from Ms. Ferguson. Yes.
Thank you.
You're welcome.
It is.
Is the attorney here on Fabian Cardenas?
I'm here, Judge.
Hi.
How are you?
All right, good seeing you. How are you doing?
Good. Oh, I'm not just.
Oh, everybody always does that. They're like, what is this? Let me go around it.
I'm here, Judge. Did Fabian check in this morning?
He's right here.
Oh, there he is. Hi, Fabian. How are you?
Hi. So what's happening with this case?
Judge, it's a first setting. I believe we were just retained on the case. I believe my office filed a notice of appearance. We're kind of in between criminal lawyers right now. Sergio Ibarra is coming on the 23rd, so I'm kind of filling in. I just reviewed the case and gave it to the prosecutor for an offer. There wasn't an offer written in there, so that's where we're at.
See, and you had posted everywhere that you're no longer doing criminal work. This is like The Godfather. Once you get in, they pull you back in.
Much rather be over here any day. Of the week. Let me tell you, it's not civil over there.
No, I've been there.
Yeah.
All right, Ms. Ferguson, can I have a 30-day, well, a regular reset on Cardenas, please? A regular reset. All right, so we're gonna come back on February 13th. They'll give you a reset form.
And Judge, I'll make an offer before she leaves.
Okay, all right, thank you.
Yeah.
Fabian Cardenas.
It's pretty odd. That's- It's good. It's fun. Yeah, I didn't take a picture. We had like a chef dining experience at Nobu. Where you don't, you just tell them, just bring me what is the best. And they like bring me courses. So that. I wonder, Judge, have you done that?
What?
The like chef's table experience at Nobu?
No, I have not. Bring me whatever.
Yeah.
This is what I'm allergic to.
Yeah, they asked for that.
Okay, I'm gonna have to do that. So where did you?
And then my brother knew about it. I think it's like 25.
Okay. See, to me, you should do it once, right?
Yeah.
Okay, I'm gonna do that.
I was like, kind of like, yeah, I might get off that, but yeah, everything. I was like, wow.
Yeah, I saw your photos. I'm like, oh, that's so great. It's sometimes great to get away.
It was nice. It was fun.
That's good. You know, Richard is in Egypt posting his Egyptian photos. Yes,
And like,
I think so. But he's, you know what? I think he's taking a second trip around and say, you know what? Was this as good as I remembered it? You know, did I miss anything? You know, we should get a bunch of attorneys together and we should do that around the world in 80 days and see, you know, and do a race, see if we can do it.
I know.
I don't know if John Kuntz would get left behind though. I told her,
around the world in 80 days or something.
you know, Richard is doing another around the world thing with Denora. And so
I saw her on the news complaining about the airport a couple of weeks ago when all the delays were going on.
Yes.
I was watching, it's like, that's Denora.
yes, yeah. But so they took a photo. He's on a camel and it's like he's holding the pyramids up because he does the photo. So I was telling Amy, we should do a contest with attorneys around the world in 80 days, you know, and see if we can make it like they did in the book.
I don't know if I can make it around the courthouse maybe.
Oh, I know. I mean, it's like, I have 30 settings.
But you know what I would do as a part of the Around the World in 80 Days? The first thing you would have to do is file a motion on the civil side during presiding docket. And we'll see, that will slow people down.
Yeah.
How could I get 80 days off from PayPal? Like who, I would go broke.
I think we have to Zoom everything. I'm in the hot air balloon.
Yeah, no kidding. Crazy.
All right, is anyone else ready? Because we're bringing the jury in at 10:30. So is something happening that I need to know about?
As far as I know, Jack.
Okay. All right, and where is Santon Wilson? All right, thank you.
Thank you, Judge.
You're welcome. Have a good one. All right, and where is April Gonzalez? April Ramirez, April Gonzalez, where are you? All right. No, we're waiting for her attorney.
He was here.
Okay.
Yes.
Yeah. What did I do? Did I do it wrong? Yes. Sure. Excuse me, I'm behind you.
Okay, okay. Okay.
Okay. Okay. Yeah, so Alan's.
What?
So he's looking to get, what is he on the birth? Like he was. Okay. Yeah.
He's got the screen. It's been good. Yeah. I think it's all right. You know, now. Yeah, that would, you know, easy.
Yes.
Oh, that's.
Well, it's just. Such a good. Of course.
Rudy retired, but okay, yeah. There's not, right? So this guy, he has a counterfeit.
Yes. I just couldn't find the fish for you.
Oh, you got 4 years over here on that. Looks like. Then an MCR filed 6/14/2018. Oh, okay. Okay, so we need a date. Okay.
Thanks for
Okay,
turning this in.
I'll-
Thank you.
let me- I'll talk to Alan, just to make sure that. Okay. We want it on. Yeah. Okay, so you don't need it from the over. Okay. Oh, yeah. Yeah, whatever. I like that. Jerry coming up. It's just. What are y'all trying?
I divide our cases into categories. Lot shouldn't hurt and. I don't. I thought he.
Yes.
Just get a reset so I can confirm what this is.
Gregorio Cantu.
Mr. Cantu?
Hello, good morning. All right, what's happening with Mr. Cantu?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Cantu.
Has an offer been tendered?
Offer has been tendered, Your Honor, for the court's information. I'm going to be filing a motion for evaluation on Mr. Cantu. And that will be done this week. I'll file that motion.
All right, Ms. Ferguson, we're gonna need a evaluation done on Mr. Cantu. Can I have a 45-day reset, please?
I think it's $200.
I'm sorry?
I think it's $200.
I'm sorry, what did he say?
It's $100. All right, I'll take that one instead.
March 23rd.
All right, so we're gonna come back on March 23rd.
Okay,
Thank you.
Your Honor. Thank you, Your Honor.
You're welcome.
May I be excused?
Yes.
Thank you, Judge.
All right, and Ms. Ferguson, if you can make sure that competency is filed.
Yes.
All right, who's here on Ramirez? Yes.
Good morning.
Good morning. Where is Victor Ramirez Acosta?
It's in ICE custody in Crime City, Your Honor.
Okay.
And I'm conferring with the state.
Debbie Cruz on behalf of the state, Your Honor.
Okay. All right, Ms. Ferguson, I need a 45-day reset on Ramirez Acosta, please.
March 23rd.
All right, so we're gonna come back on March 23rd for an update on the ICE hold.
Okay, thank you very much.
All right, thank you. Have a good one. Good seeing you.
Good to see you too. Let's see if we can get a reach.
All right, who's here on Jesus Solis? Guillermo Lozano. Where are you?
He's there in custody, Your Honor.
Oh, it shows him on phone, okay. And then what is happening with April Ramirez, April Gonzalez? Is that done?
Your Honor, her lawyer was here earlier, but has not returned.
All right, so we're gonna start up with our jury trial. So everyone whose attorney has not been here, you're gonna have to wait for your attorney to appear. Oh, sure. Which case is this? All right.
The GFBI judge.
And Norman, you need to have Mr. Cox come back.
Yeah.
All right, we'll bring it back on. You're saying next week?
He said, yes.
All right, he can come back on Wednesday,
Wednesday? Yes, ma'am.
and his client is in custody, correct?
Yes, ma'am. That's correct.
All right. Guillermo Lozano, your attorney is requesting that you be brought back on Wednesday, so we'll bring you back on Wednesday, the 25th.
Yeah. Maybe not. Just that car trouble and got in with this.
Bye, have a good day.
Bye-bye. Have a good one. Don't be a stranger, even though you've gone to the civil side.
I know, I see you. It's okay for you to remember. Even if it's me. Go back to
Thank you.
No, that hasn't been withdrawn. Yes.
We got our paperwork in.
All right. Oh, as soon as I get it, we'll go.
Perfect.
And then after that, we will bring the jury in.
And so my jury.
Judge, is that your picture?
Yes.
I thought I saw it back there, but I mean, I like.
Well,
that.
now,
It's
let
a
me
print.
just tell you, it's mine because it was gifted.
Oh.
So this is the story of that. Michael DeLeon had two of those. One was scratched. So he told the person, hey, you all scratched the photograph that you gave me. So the guy said, you know what? We're going to replace it, but you can keep the one that you have. So I can't see the scratch. So I don't know if this is the scratch one or not.
I mean, a track like in the picture.
Yes.
I mean,
So I can't see it either. And you know what's hilarious about that? We all wear glasses and we can't see it.
I think family violence.
Yes, family violence. He's in Judge Mary's court. But he did have another beautiful one that is so beautiful. It's a longhorn in a field of, what do you call those flowers that we have here?
Blue bonnet.
Blue bonnets.
Oh, yeah.
And I'm just like,
You have been here long enough, guys. That should just roll right off.
it should roll right off
I know. The Louisiana is stuck to.
like Rose of Sharon. Roll off like that. But you know, I still can't find any honeysuckle here. I go and I try to get honeysuckle.
I've seen it off the side of the road near my house.
So you're inviting me to drive, put on my flashers and pull honeysuckle off the side of the road.
I don't think it's in bloom right now, though.
Yeah, they never have it when I go to the store.
You need a tiger. You don't want longhorns. You need a tiger.
Oh, well, I need a picture of a tiger in blue bonnets. That's what you're saying. I think the colors would clash.
I'm pretty scared of a tiger.
Yeah.
Poor young gymnast that is being stalked by everyone at LSU.
That's just, and I'm like, why? Why people?
This seems to. Why her? Like, why, what is the fixation?
My understanding is that she's on, what is it, OnlyFans or Fans Only or something?
So she's pretty-
So, yeah. So that's what's happening. All right, Norma, have you been in touch with Mr. Cox?
I'm getting here. I'm trying to contact Angel. I don't have his numbers. I need to go to Angel.
All right, we're gonna go on the record. Court is calling 2022 CR 11169, State of Texas versus Douglas Hughes. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
John Coons for Mr. Hughes.
And are you Mr. Hughes? Counsel, have you received all the discovery in this case and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hughes, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding with the lesser included Class A misdemeanor, DWI second.
Any objection?
Obviously, no objection from us.
Oh, sometimes people do have objections. All right, Mr. Hughes, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on DWI second as a Class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Very much so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes and yes.
Mr. Hughes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, sir. No.
I'm sorry?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on lesser included offense of DWI second as a Class A misdemeanor. Punishment is to be assessed at 1 year in the Bexar County Jail. There's a $2,000 fine. There are no applications for deferred adjudication. State recommends community supervision. They will take in consideration 658-256, 658-257, and there's to be restitution, if any, to Toyota Lease, LEASE Trust. Did you understand that to be the agreement?
Yes, ma'am.
Defense?
Yes, sir.
State?
It is, Your Honor.
Show you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 120 hours of community service restitution, and ignition interlock for half the term of probation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the DWI, second, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
We reviewed them and have no objection, Your Honor.
Mr. Hughes, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We would request, Judge, before you do, just a couple of things about Mr. Hughes. He's actually been in recovery now for almost a year. He's been sober for about a year. He's had the Scram device this whole time. He would actually like to stay on the Scram device for now. So in lieu of the ignition interlock, I've discussed this with Mr. Garahan. He didn't have any objection to that. There may be a time in a few months. My client isn't driving right now, but if he starts driving again, he might request the ignition interlock to be swapped out. Also, Judge, and I didn't discuss this with Mr. Garahan, but with regard to the fine, if there's anything you can do to mitigate that amount. I've known Mr. Hughes for a while. I call him Andy, and Andy works 2 jobs at 2 different restaurants. He's a hardworking guy. He's doing well in his life at this point. And so if you could help him out in any way with regard to the fine and the probationary fees or anything like that.
All right, so he's not driving?
He is not currently driving.
All right, so you mentioned that he is, I guess he works as a cook.
He works as a waiter at restaurants.
What is a stripper taco?
A what?
Well, I always read everything in the police report.
The place on St. Mary Street outside there's a location on St. Mary's that had a little food truck there.
Right, yeah.
And they were called stripper tacos.
Oh,
It was because it used to be in front of Hard Bodies. It was a male dance club and.
I was wondering if there was like a stripper taco, like, was there an ingredient? And so that's why I was reading. I'm always interested. And so now, when I say I read everything, I actually read everything, although it appears that I'm speed reading, but I read everything. So I was wondering about that. So what type of treatment are you in?
Well, I've been going to AA meetings and just not drinking. I'm not like in a treatment program per se.
You also went to rehab though.
Yeah, I did go to rehab.
How often are you doing your sober meetings?
3 to 5 a week, depending on my work schedule.
All right, this is what the court is going to do. The court is finding you guilty. The court will order scram for half the term in lieu of ignition interlock. There's to be no driving. As long as you don't have ignition interlock, you're not allowed to drive, and you're going to have to do an affidavit of non-driving. There's a $2,000 fine that will be probated, sentence you to 1 year in the Bexar County Jail, suspended and probated for 2 years. Taken in consideration 650-8256, 658-257. You're to continue with your sober meetings 2 times per week. DWI education course. Do you have any children?
No.
All right, 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with booster. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. What are you planning on doing with the rest of your life?
Am I planning on doing?
Yeah, are you going to continue to be a waiter or work? What?
I mean, for right now, I kind of have to. It's just all I've done since I was a kid.
I mean, what do you want to do with the rest of your life?
Still trying to figure that out.
Oh, all right. So he's doing a gap year for, how old are you?
It's like a gap decade.
Oh, okay. See, he knew where I was going. All right. And then there's to be regular reporting and regular UAs, and your reporting can be by Zoom or in person. Is there anything else you need from the court in order to be successful? No. Probation is.
You mentioned DWI education. Is there a big panel?
Yes. Thank you. And VIP. Anything else from either side?
Not from the state.
No. You're gonna sign the dismissal on the misdemeanor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because it's plea bargaining agreement, because I followed your, one other thing, I'm sorry, there's restitution. If any. To Toyota Lease Trust.
Your Honor, I apologize. One more thing. Did you want to do field visits or anything like that?
We can do field visits once a month or as needed by probation.
Okay, thank you.
Thank you. All right. Now I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We can go off the record. So here's my spiel about the DWIs. Everybody has heard this. My statistics professor will be upset with me if I did this because I haven't done a statistical analysis. It's just what I've seen. And what I've seen is people who drive while intoxicated, usually if they end up in an accident, they're just fine. Usually they end up killing somebody on their way to a soccer game, or either their passenger ends up dying for some reason. Usually the person who's intoxicated, they survive everything. And then, you know what ends up happening? They come to court, and I've represented people who come to court, they're crying because they never intended to kill somebody, but they did. Don't be that person. Continue on the path that you're on, okay? All right, good luck to you.
Thank you. Thank you, Judge.
You're welcome.
Thank you, Jesse.
Yes, sir. Have a good day.
Yeah, you too. Thank you.
All right, can I see the file on today's Cox case? And where is Mr. Cox?
Step out to the back page.
It disappeared.
Yes. And Deputy Laura, the only jurors are 7 and 29, is that correct? Everybody else is here?
No, Your Honor, we're missing 7.
Okay.
We're missing 16.
Mhm.
29,
Mhm.
49,
Mhm.
55,
Mhm.
5.
Said Mr. Juror sent him up.
Yeah, no, that's not the way it works. Who is he?
Alfredo Tobias.
Yeah, tell them that's not the, unless he came on the panel, like on the list, he can't just request to be on this panel. But I appreciate that he wants to be here.
Volunteers. Can't turn out volunteers.
Yeah, because I'm assuming you are gonna have an objection. His name and information is not even listed.
You probably wouldn't qualify.
Well, no, just tell him to go back to the central jury room. All right, we're gonna go on the record. Mr. Wilson, can you come forward, please? Let me see if I can find the indictment. Oh, here we are. All right, the court is calling 2019 CR 4004B, State of Texas versus Santuan. And it's listed as Wison, W-I-S-O-N. Could our parties announce for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Cornelius Cox for the defendant.
All right, and are you ready to proceed with jury trial, counsel?
Yes, Your Honor.
State's ready.
All right, and so state, are you proceeding on the indictment as presented?
Your Honor, there was a motion or notice of enhanced punishment that was filed by Marcus back in 2020. So that has been in the court's file for a while. Also, I believe Marcus filed a motion to amend the indictment to correct his last name from Gleason to Wilson.
Have you been given?
I don't know anything about the amendment.
All right, I don't have a copy of an amendment in the court's file.
Okay, I could double check again, Judge.
I'm sorry?
I could double check again. I could have
Okay.
sworn I filed it.
I mean, I have the severance from Derek Alexander, which was done.
And Judge, I see that he placed one in the state's file, but I could double check if he actually filed it.
Okay.
When I saw that.
Oh, sure. Let's see if it's been filed. All right, thank you. My understanding, it has been filed. Yes.
It Judge, it was signed. We do see it online.
I'm sorry, what?
We do see it online. It was signed.
Oh, it was signed?
Mhm.
Okay.
Because it was always gonna bother me. We send.
And when was that order signed?
Oh, you know, Jason, when it was signed.
September 28th, 2002.
2000 when?
20.
All right, thank you.
Would you like me to print out a copy for the court's file?
They're printed out on the back.
Fucking Jesus, not fucking grab me that way. And my birthday is 1965, not 81. I don't know who the fuck is fucking changing it.
All right, so, it's Wednesday. We have an issue. People love to be in the 187th because she's not even on the docket in here. Yeah. It's still going to be a beautiful day. All right, while we wait for that, the other issue is these are the following jurors that are missing. 7, 16, 29, 30, 49, 55, 65, and 73. Any objection to proceeding without those jurors?
In this case, Judge, no, I do think the family files is still preparing, so I didn't want to speak to them on their case.
I think we would prefer to full complement.
All right, I know you would prefer that, but any objection to that? All right, that will be overruled. All right, and Mr. Cox, the order has been signed with regards to the name change, and I do know that each time I've called this case, I've called him Weeson, and I've been corrected each time by the defendant and yourself in the state that it's actually Wilson. So it does show that the order was signed on September 28th to amend the indictment to add an L to his name. No, let me see. Because what day was that signed?
Okay, September 28th.
All right, because his previous attorney was Ed Camara. So I think that may have been done under Mr. Camara. Yes, that was done when Mr. Camara was his attorney.
Was it?
Yes. So the amendment of the indictment, that occurred under his previous attorney, Ed Camara. So that's why you probably are not.
Was it in open court when it happened?
We'll have to have the record pulled for that, but I'm pretty sure it was because I put everything on the record. And then this is the notice of prior use of enhancement that was filed on September 24th. And again, I think that may have been before your time as well, Mr. Cox. All right,
Was that done?
well, just 1 second. The dates on those are when? September, is it September 2022?
September. Like it was filed September 20.
No, but what year?
2020, that's when it looked like when it was filed.
No, at the top on the, let me see.
I think it was in 2023.
Yes, so the 2020 dates, that was Mr. Camara.
And that was done in open court.
It would have been done in open court because I have everyone confer on motions. Then we hear them. All right, if you want to, I don't know if you want to confer with your client about the enhancement portion, do you need to confer with him about that?
I think I need to, and if, and like I say, it would be important to me to know whether it was actually done in open court.
Well, I can tell you the notice to seek enhancement was not done in open court because they filed it. And hopefully, or supposedly, that was tendered to defense. Because I'm not in charge of whether or not they're seeking to do enhancement, but I'll allow you to confer with your client on that.
Thank you.
Thank you. So you guys can step back. All right, and then what is the case for family violence? What case do you have, please?
Oh, we have Jose Perez.
All right, can I see Jose Perez file? And is he in custody?
He's on bond, Your Honor.
He's on bond. Do we have the immigration person, the interpreter?
I'm sorry. My apologies.
All right, who's going to be the attorneys on Perez?
For the state or for the defense?
Defense. All right.
It's me, Your Honor.
All right, we're not on the record yet, but do you know about the missing jurors? Are you going to have any objection to those jurors being missing?
Record, yes, I'm gonna have to object, Judge.
All right, and we'll put that on the record. How long is it going to take you all to do voir dire?
Just listen first and then when. And Judge, I got some grace. I'm asking for, I think we're both asking for an hour and hopefully giving you some time back. There's several issues on the case, Judge. It's just an adult sex case.
Okay,
Presents more issues.
but I know you guys are going to give time back. That's okay.
Trauma.
All right.
If you're dealing with some issues, Judge, we may have to. Obviously, the interpreter issue. I haven't moved everything in my docket except for 2 cases. I have a federal case tomorrow morning here in San Antonio at 9 o'clock. I didn't move that because the guy's been in custody way longer than the Senate calls for. So I don't know if you can do it in 30, 40 minutes in the morning.
Okay. Yes.
Got the same issue out of town on Monday.
Oh, I anticipate y'all may be done before Monday. We shall see. We can always be here on Saturday or Sunday.
In my understanding, Judge, we have a docket tomorrow, so we wouldn't be doing testimony.
Yes.
Okay.
That solves that issue.
Okay, awesome. So are they sending an interpreter?
Yes, ma'am.
And Judge, can you repeat the numbers of the missing jurors?
7?
No, Judge, it's number 7, it's number 16.
Oh, so 7 is here?
7 are missing.
Ah. All right, so it's 16, 29, 30, 49, 55, 65, and 73.
Thank you, Judge.
Mr. Cox, do you need more time?
Or just only in terms of,
Yes or no?
yeah.
All
I know
right.
time is well spent, so. Okay, then the court gets to the point, quickly. So, I like to warm up, just like old Baptist preachers.
Well, I had a conversation about the emails I sent out because my emails, I'm like, in the words of John Wayne from the Cowboys, we're all here to do a job. We're just doing our job. So I would send my emails out, and if something was needed, I would say, excuse me, I need this witness subpoenaed now. Stephanie Boyd. And so somebody's like, your emails are very harsh. You need to work on changing your emails. So I changed my emails, and you know how I changed them? Good morning, how's your day going? We need this subpoena today. And then I would end it, thank you, Stephanie.
Okay.
So, all right, because I do realize that I guess you were not aware through no fault of your own, because you were a new attorney placed on it, that the state has enhanced this case. And also that they did change the name in the indictment from Weeson to Wilson. So, Ms. Ferguson, I want Mr. Weeson brought back for jury trial, fitted in like 2 to 3 weeks. All right, we're coming back on February 6th. All right, and I expect you all to confirm February 6th, because your attorney is now aware of the enhancement, will be your plea deadline date and your jury trial date. Court will not extend the plea deadline date any further. The court will not extend your jury trial date any further. All right, is there anything else? And as always, you both were dressed, well, you always dressed appropriately for court, Mr. Cox, but your client is always dressed appropriately.
That's a pretty job.
Yeah.
Yeah, hold on, I just do it. But they always give us a reset.
Oh, yes.
Actual paper reset.
And on this case involving Mr. Perez, if he were found guilty, are you going to the court or the jury? Who is this? Jury, okay. All right, if everybody will take their places, as soon as the interpreter gets up here, we're going to proceed. Hello. Hi, it's so great to see you. All right, Happy New Year. Thanks. All right, so we have, the defendant is Mr. Jose Raymond Perez. The cause number is 2022 CR 2308.
Okay.
All right, and that's your, the person you'll be interpreting for right there.
He's defendant.
Yes, no, they need to come back on a break.
Yes.
You're welcome, bye-bye.
Señor, ¿se va a sentar ahí al lado de su abogado?
Gonzalez, your attorney, for your attorney, and do not leave the courtroom, do not leave the hallway, that will come right after a break.
They are on call.
Oh, there's an extra chair. being completed up there. I don't know if you wanna- No, it's up to you. Some call.
Sure. Okay. No problem. All right, court is going to call 2022 CR 2380, State of Texas versus Jose Raymundo Perez. We have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear or affirm that you will faithfully translate from Spanish into English and from English into Spanish, so help you God? All right, you can lower your hand and you can have a seat here if you wish.
Yes.
All right, could I have the parties announce for the record, for the state, for the defense?
Good morning, Your Honor. Raymundo Perez.
And is your client, are you Jose Raymundo Perez?
Yes.
All right, you may be seated. All right, the court has been informed that the following witnesses, the following potential jurors are not present. Juror number 16, 29, 30, 49, 55, 65, and 73. Any objections to proceeding without those jurors? State,
No, Your Honor.
defense?
The defense does object, Your Honor. My client is entitled to count of his peers. There was maybe one or two, that would be one thing. At this point, I think it would be a sufficient number that would affect the breadth and variety of jurors that can get this to have listened to this.
All right, that objection will be overruled. State, are you proceeding on the indictment as presented?
Yes, Your Honor.
And defense, have you received all the discovery?
I have none.
All right, the court will find that the state is in compliance with discovery and the court is in receipt of the two discovery acknowledgements. Are both parties ready to proceed, state?
Yes, Your Honor.
Defense?
Defense is ready.
All right, and defense, this is the court understanding that you'll, if Mr. Perez were to be found guilty, you'll be seeking the jury to proceed with punishment?
That's correct.
All right, thank you. We can bring the jurors in. Yes. Oh, it doesn't lift up?
Sorry.
No problem. That happens to me too. Is that okay? Okay. All right, would you like to,
All the way to the end, and
Over
there's
here?
numbers on the chairs.
you can sit over here behind me if you want to.
There's numbers on the chairs. She can sit here. Number
All right.
8. Number 8. Yeah. If you're in a second.
Yes. All right, sure. You're welcome.
Yes, ma'am. You're welcome. You'll have a chance. 15. Start at the bench. 22. Next room.
Chris Lowe.
Next room.
Six.
57?
All right, everyone, please be seated. All right, everyone, good afternoon. All right, that is like extremely slow. Good afternoon, everyone. All right, you are in the 187th District Court. I know you all were here yesterday, so welcome back. I'm Judge Stephanie Boyd. I preside over the 187th District Court. You are on the 4th floor. So our courtrooms recently moved because we used to be at the other end of the hallway. So now we are here. So which court are you in? What floor? And who's the judge? And I know what you're probably saying. She just said that. Why is she having us repeat this? The reason why I do that is because, believe it or not, people who are selected to be on juries, they get lost sometimes. Sometimes they end up at another courtroom and we're waiting for them and nobody can find them. And they're in another courtroom trying to be on that panel. And it happens every time we have a break that a juror will look up and say, well, everybody was gone and I didn't know where I would go. So the reason why I tell you that is because if you're ever lost, you remember the 187th, you remember the 4th floor, and you remember Judge Boyd. I'm the only Judge Boyd in the entire courthouse. So even if you were to go to the red brick building, They would tell you, there's no judge board over here. There's only one. So you won't get lost. I've introduced myself to you. Now I'm going to have the parties introduce themselves for the state.
Good morning, y'all. Michael Villarreal.
Good morning, Brittany Mitchell.
And for the defense.
Good morning, folks. Albert Flores.
All right. And if your client could introduce himself, please.
Jose Raymundo Perez.
Jose Raymundo Perez.
All right. So I know what you're asking yourself. Why is she repeating what he just said? So we have an interpreter in this court, and that interpreter says everything that everyone else is saying, but she says it in a different language. So in this case, she's repeating everything in Spanish. She has the headphones on, and Mr. Perez has the headphones on so that he can hear what she is saying. I think languages are beautiful. I'm originally from Louisiana, so of course, I thought it would be great to learn French. My idea was I'm going to be living in Paris. Obviously, I'm not living in Paris. In some way, I ended up in Texas, and so I should have taken Spanish, as my other friend was encouraging me to do so. When I ended up going to school, in undergrad school and grad school and in law school, other people could speak all these different languages. So they were trying to teach me languages. So I can speak several languages, but I only know one word, and that's the word hurry up in every language. That's the only thing I could learn in Navajo. That's the only thing I could learn in Arabic. So if we're out somewhere, I can say hurry up. So you look to me for that. So I say that to ask, is there anyone who's going to hold it against Mr. Perez because he's using an interpreter? All right, great. Because sometimes people's first language is not the English language. They can speak English, but sometimes for important matters, they feel more comfortable if they are being spoken to or they can hear things in their native language. All right, the other thing I want to tell you, you have something very important in your possession. They're cards. They're cards with numbers on them. Does everyone have a card? Yes. So can everyone please raise your cards for me? Awesome. Okay, you can lower your cards. Now, when people ask questions of you, or if there's something you want to say, so things can be done in an orderly fashion, just raise your card with your number showing. And then that way I will know, or the state or the defense will know that you have something you wish to say. And it makes it easier on the court reporter. Court reporter is right to my left. She is taking down everything that everyone is saying. And our job is a little extra difficult today because we have an interpreter. So she's going to be taking down what the interpreter is saying. And everybody speaks at a different pace. So I'm going to ask everyone to please speak up loudly and clearly so that she can hear. And let's all remember there is only one person speaking at a time. Now I'm going to give you some other instructions that no jury has been able to follow, but I have confidence that you all will be able to follow. If you're in the jury box, and if you're on this front row, you do not have to stand when you speak because everyone will be able to hear you. If you are on any other row other than the jury box in this first row, if you can, when you're speaking, I'm going to need you to stand so that the court reporter can hear. I wear glasses. I see some of the people out there who are wearing glasses. People who are wearing glasses know that if we cannot see you, we cannot hear you. Something happened when we got glasses. We need that. I see people with glasses shaking their head. They know what I'm talking about. So the charge in this case is sexual assault. And I just want you to think about that for a little. Then I'm going to come back to that. So when the state and the defense talk to you, they're going to be speaking to you in hypotheticals. Remember, everything they say to you is not specifically about this case because they're not allowed to go into the facts of the case. The only way you're here specifically about this case is if you're selected for the jury, and then evidence will be presented to you. So always keep that in your mind. that during this selection, everybody is speaking in hypotheticals. Does everyone understand?
Yes.
All right. Now, I want to talk to you about an indictment and what an indictment is. And this will give you a chance to use your cards. How many people in here have ever had a traffic ticket? Don't be shy. We will close our eyes. I see there are some of you who've never had a traffic ticket. Now, when you have a traffic ticket, I've had one in my lifetime. Sometimes it's a ticket, maybe you didn't fully stop at a stop sign. Maybe you didn't use the yield sign correctly, which people in San Antonio don't use the yield sign correctly. Or maybe you were speeding or didn't wear a seatbelt. So when the officer pulls you over and gives you a ticket, now they do electronically. They used to have the paper. When I got my ticket, they had the little paper thing and they give you a paper pad and then they have to turn in that paper pad to municipal court. But when they give you that ticket, they are not saying, well, you're not saying, oh yeah, I'm accepting this ticket and I ran a red light, or I'm accepting this ticket and I didn't follow the yield sign correctly. That ticket is to tell you what the officer is saying you did. So when they pull you over, the ticket will tell you, I'm saying you ran the stop sign. This is where you're going to meet to address the issue of my saying you ran the stop sign. And usually it's on Frio Street. And then at that point, you can decide whether you want a jury trial or not. So an indictment is similar to that. An indictment is not an evidence of guilt. It can be not taken to mean absolutely anything. It is merely the document that's used to bring someone to court. So in felony cases, people are brought to court through an indictment. And the indictment is to give them notice to say, this is what we're accusing you of. This is where you need to be. And this is the time that you need to be there. Does everyone understand? All right. So everyone understands that you are not to take the indictment as evidence of guilt. Does everyone understand? Yes. And you're not to take it as any evidence at all. Does everyone understand? Okay. Now, I mentioned earlier having everybody introduce themselves. Does anyone know any other parties that introduced themselves? All right. Other than meeting yesterday in the hallway or meeting downstairs, do any of you know each other? Okay, that is odd. Usually there's a school teacher who has a student. I mean, we once had the ex-wife and the current wife, but they were fine with being on the panel together. All right, so how many of you all have seen the legal shows? Quincy Jones, Mannix, Barnaby Jones. See, somebody's in my age category. Thank you. Paper Chase, The Practice. All right, now we're getting there. Beretta. Thank you. Oh, there's so many young people. I guess I'm getting very old. All right, so in there, how many of you have heard of, well, The Rookie? Thank you. See, that's today. Thank you. You know, okay. I see you're a Tim and Shin fan. Okay. How many of you have heard of Right to Remain Silent? Is there anyone who has not heard of Everyone Has the Right to Remain Silent? Oh, wow. So we have some people who are not reading, not watching television. Okay, so the right to remain silent, that's a constitutional right. So anytime someone is accused or charged with an offense, they do not have to give testimony against themselves. For example, if I were on trial, the state can say, well, I'd like to call Stephanie Boyd. So I have a right to remain silent. And the reason why I have that right is because the state has the burden to prove their case. Someone who's charged with an offense or accused of something, they don't have to prove anything. The person who's bringing the charge has to actually prove it. Does everyone understand? And so because a person has a right to remain silent, you can't hold that against them and you can't consider it in deliberating on whether someone's guilty or not guilty. Does everyone understand? Is there anyone here who will hold it against Mr. Perez if he chooses not to testify? Okay. All right, the next thing I want to talk to you is about the presumption of innocence. Everybody is presumed to be innocent unless and until the state proves their guilt beyond a reasonable doubt. And people always say, what is beyond a reasonable doubt? What does that mean? Well, when I was in law school, there was a definition. You had to memorize that. If you didn't memorize that definition, you felt like you had failed. Your parents have spent this money and you have failed. My first jury trial, I knew the definition backwards and forward. I said it. I was so proud of myself. And after that jury trial, they did away with the definition of proof beyond a reasonable doubt. So there is no definition for proof beyond a reasonable doubt. And as a former defense attorney and as a former prosecutor, what I would do in jury trials is I would tell people what it wasn't to help them. So in the building that's across the way that has the green rooftop, they handle civil cases. The burden of proof on there, they have two different burdens. One is preponderance of the evidence. More likely than not that somebody did something. Usually that's involving your car accidents, that type of thing. The other one they have is called clear and convincing evidence. And clear and convincing evidence is what you need in order to terminate or take away someone's parental rights. So this is saying you will no longer legally be allowed to be a parent to your child. Does everyone understand? Well, those burdens are a lesser burden than proof beyond a reasonable doubt. Proof beyond a reasonable doubt is the highest burden that we have. Does everyone understand? Now, there are two phases to a jury trial. The first phase in Texas is where you make the decision on whether someone is guilty or not guilty. That's it. Does everyone understand? If you say that someone is not guilty, there is no second phase, which is called the punishment phase, because you found them not guilty, so there's no punishment. If you find somebody guilty, then you go to the second phase, which is the punishment phase. Does everyone understand? All right. Now, in this case, the range of punishment is anywhere from 2 to 20 years with possibility of probation. Is that correct, State and Defense?
Yes, Your Honor.
All right.
I'm sorry, I didn't hear you, Your Honor.
With the possibility of probation.
Yes.
All right. So in a case where someone is charged with sexual assault, the range of punishment is anywhere from probation up to 20 years. That is a wide range, right? You can give somebody probation, you can give somebody 2 years, all the way up to 20 years. Now, the question is, can you consider the full range of punishment? Now, sometimes jurors get confused on this because they say, oh, well, I would never give this. I would never give that. The thing about it is, you don't know the facts of the case. So you can imagine in your mind where, if these were the facts, then maybe I would give somebody probation. If these were the facts, maybe I would give somebody 2 years, 3, 4, 5, all the way up to 20. The only thing I want to know from each of you is whether or not you can consider the full range of punishment. And when you're thinking about punishment, if you get to punishment, that you will apply whatever facts there are to what you think the punishments should be. Is there anyone here who cannot consider the full range of punishment? Okay. The next thing I want to talk to you is about the one witness rule. This is another thing. Jurors always start asking questions, but I'm going to give you a hypothetical with the one witness rules. Do not add anything to the hypothetical I'm about to give you. There is no lighting issue. There is no person who has glasses. They have perfect vision. The only person who has a vision more perfect than theirs is Superman. So listen to my hypothetical. You have an offense that's alleged to have been committed. The state calls a witness. The witness testifies. The witness proves all the elements that the state needs to prove in their case. Every single element, they're able to testify to it. Now, you're listening to that witness testify. You believe the witness. There's no issue with that witness's credibility. Does everybody understand the facts? You can make the witness Mother Teresa, it can be the Pope, whoever it may be. It's a witness. You believe the witness. You find them credible. You think they're telling the truth. And that one witness proves the state's entire case. Does everyone understand the hypothetical? Then the question becomes whether or not, based upon that, in that fact scenario, you will be able to find someone guilty. And I'm not talking about Mr. Perez. We're speaking in hypotheticals again. So is there anyone who would not be able to follow the law in that situation and find the person guilty if you have no issue with that person's credibility, if that person's testimony proves the state's case? Is there anyone who would not be able to find someone guilty with that? Number 4, you have a question?
What if, is there no proof besides just the testimony?
No, I've given you the hypothetical. You believe that person. It's similar to, and I've heard this example done before, it's similar to if somebody is walking down an alley and that person is walking down the alley, somebody mugs them. There are no videos. There are no photos. That person grabs that person's purse or wallet and they leave. And that person comes into court and they say, yes, they took my wallet, they took my purse. I called the police and I saw the face of the person who did it. And, you know, it's this person or it's that person. And you believe that person's testimony and there's no issue with their credibility. Would you be able to find someone guilty if there is no issue with regards to credibility and what they've testified to has proved every element of the state's case? Is there anyone who would not be able to do that? All right, number 4. Okay. Now, the next thing I'm going to ask is with regards to languages. Is there anyone here whose English is not your first language? Pull up the cards. All right, number 5, 39, 61, and 62. All right, juror number 5, have you been able to follow everything that we said?
Yes.
All right, juror number 39. Stand up for me, please. All right, have you been able to follow everything that's been said? All right, thank you. Juror number 61?
Yes.
Juror number 62?
Yes.
All right. Now, the next thing I want to ask you about is travel arrangements. Is there anyone here who has some sort of trip planned? The tickets are non-refundable. You can't put them in my name. All right. 52, I'm sorry, 36, 52, 64. All right, number 36, what is your time constraint?
This Friday,
What are you doing this Friday?
I'm going to New Orleans.
Oh, are you really going to New Orleans? Or are you just saying that because you want sympathy from me? What are you doing in New Orleans?
It's my birthday.
Who are you going with?
Friends of mine, longtime friends.
Are they paying?
Yeah. Somewhat, yes.
Okay, all right, thank you. Number 52? Yes.
Today at 2:00, I have a flight.
A flight where?
To St. Louis. Do my cousin. She has stage 4 cancer. She's in the hospital. Uncle passed away this weekend. So just family situations.
Okay, all right, thank you. 64?
Florida,
What are you doing in Florida?
wife's birthday.
Does she want you there? I mean, sometimes people want to celebrate by themselves. When is that?
27, 20.
Okay, you don't even know. 27, 28. She's going to be upset with you if you don't remember. When is her birthday?
The 28th.
Okay. All right. Can I have parties approach, please? All right, everyone, I normally don't do this, but I'm going to allow number 52 to be excused because I don't want you to miss your flight. And I hope all of the other jurors understand why that needs to be done. All right, we're sending prayers. Because sometimes when you go to the airport, there is no parking space. I've been there when that has happened. All right. I'm going to tell you all two stories. And before I do that, let me let you know. Sometimes you have people come through these doors. Sometimes they come through these doors. And sometimes they don't read the sign on the outside of the door that says we're in jury trial. So you'll see them come in and then go back out. And then sometimes we have observers. Sometimes there are other defense attorneys who are brand new. They want to learn. Prosecutors who are brand new, they want to learn. So sometimes they will come in and sit in on jury trials. But I want you to know when you see that, it has absolutely nothing to do with this case. Sometimes I have people who are giving me motions to review. So even though we're in jury trial, I still have a docket that's going on. So I'm going to tell you two true stories. The first one is something personal to me. It's about my uncle. And I always tell these stories to jurors because I always know that everybody would rather be doing something else maybe than sitting on jury trial. Sometimes you have people who are like, no, I really want to serve on this jury trial. But then some people are like, I had to come here yesterday. This is interfering with my life. I want to be doing something else. But when you think about it, your government doesn't ask a lot of you. Somebody reminded me, they ask you to pay taxes. Okay, they ask you to pay taxes, but you don't have to vote. You don't have to register to vote. You know, my thoughts on voting, you should, but you don't have to, right? Your government doesn't even ask that of you. They don't even draft you to go fight in wars anymore. And unless that law changes, you're not going to be asked to or be drafted. And the reason why I tell the story about my uncle, because my uncle grew up in a small town called Grand Cane, Louisiana. Population probably in its heyday when he was there, maybe about 2,500 people or so. Now it's probably maybe about 1,100 people. So that's where he grew up. So he went to school and my uncle was super intelligent. So the teachers were in charge of everything. So they kept passing him from grade to grade to grade. My mom will tell you that sort of made it difficult on his sisters because then all the sisters had to be super intelligent as well because they would say, yeah, your brother would know this or something. So when the Vietnam War started, they were drafting all of the boys in Grand Cane, Louisiana. And so my uncle said, I'm not going to wait to be drafted. I'll just go. So imagine this. That's my grandmother's firstborn child. And she had to sign for him to go to Vietnam. And he went. He's since passed, but he went. He came back. And I bring that story up because this is such a small time in our life that you're being asked to make a sacrifice to come serve on a jury trial. We always say that we have the best jury system. And some people say, I don't know if it's the best jury system. But guess what? We can't have jury trials if we don't have jurors. That's the key to jury trials. And the other story I want to tell you is about my friend that I went to law school with. She decided to do civil law. I always wanted to do criminal law because this is where my passion was. One day, she had jury duty. And she said, Stephanie, I'm finally out from the civil firm right now. I have jury duty and I'm going to come. Would you like to do lunch? I said, sure. So we do lunch. And during break, I asked her, hey, how's jury selection coming? She's like, it's fabulous. And I'm like thinking, that's really odd to say. It's not like she was in the 187th with Judge Boyd. So what does she mean it's fabulous? See, I throw my name out there again, so you won't get lost. And so she tells me I'm not going to be selected. And I said, what do you mean you're not going to be selected? She's like, it's like law school. I'm on the back row, keeping my head down, not saying anything. I started laughing at her and she said, what's so funny? I said, you're so going to get selected. She's like, what do you mean? I said, on the criminal side, what ends up happening is defense attorneys and prosecutors will look at their list and they will see that there's somebody who didn't say anything. And when they see that, they'll say, oh, well, they didn't say anything. Let's select this person. So I tell you that to be talkative, because the state and the defense have this little opportunity to get to know you, and they want to make sure that they select a jury that's going to be fair to both sides. Okay. All right. So I'm going to turn it over to the state. And when anybody needs a break, just do this sign. I will see you and we will take a break. All right. State. Yes. And to the interpreter, if you ever need a break, just let us know.
So we're still, good morning, y'all. Good morning, everybody. Again, my name is Michael Villarreal, along with my partner, Brittany Mitchell. We represent the state of Texas. So they just gave us some time to talk with you regarding this case. And so let's start with this. Who, when they got their jury summons, thought this? Try clicker work. Pretty normal reaction we get from everybody. Nobody really ever volunteers for jury duty. So we're having randomly one person today tried to make this channel who was not on the panel. So I use this to demonstrate just to thank you. I know it's not easy. I know you have to take time out of your day to come here. And I know that a lot of these cases are going to be difficult to hear. And so I just want to thank you from both the state and I'm sure the defense as well. So what is the purpose of jury selection? Yeah, what is this picture? So who here has heard of, or at least not heard of, who knows who's in this picture? I have a bunch of cards out. Let me choose you number 20. Who is that?
No. Is it Willie Nelson?
It's Willie Nelson. Man, you head there for a second, you're like, oh, I didn't think I was gonna get called on. It's like the front row class, except you don't get to choose where you sit here. So what does Willie Nelson love? Hint, it's in the picture. Number 35. Marijuana, right? So, I mean, Willie loved pot. I mean, I've heard that he, during the Johnson administration, he even smoked pot on top of the White House. So is Willie Nelson going to be a good juror necessarily on a possession of marijuana? No, right? He disagrees with the law. He just said, I'm not going to follow that area of the law, right? I like pot. I'm going to continue to possess marijuana. I continue, well, possess it temporarily at least until he ingests it. But does that mean Willie Nelson's necessarily going to be a bad juror on any other type of criminal case? Like a murder case or anything like that, right? Doesn't mean that he disagrees with that area of law. It's just this particular provision he does, right? So I use this to demonstrate this is the one time you get to tell a lawyer and judges how you feel, and we don't get to argue back. So feel free to let us know how you feel about the law, whether you agree or disagree with the law, whether you can understand the law, and most importantly, if you understand it, you just say, I can't follow that law. It goes against my morals or whatever it may be. That's what we need to find out here today, okay? So for those who are not as maybe visual learners, like people like my brothers who are a little bit more math-sided on their brain, I like to use this as an equation. So we're looking for fair and impartial jurors. What does that mean? It means that you can follow the law that the judge is going to give you, and that you're going to base your decision on the facts that are presented in the courtroom. Okay. Does that make sense to everybody? Yes. Does anybody have any questions about what we've talked about so far? Okay. So, Judge talked briefly about beyond reasonable doubt. I'm going to talk about it again. So it is the burden of proof that the state has, and that's solely upon the state. We have to prove each and every one of our criminal cases beyond a reasonable doubt. And like the judge said, that is not defined in our law. That's for you to make a determination of what that means for you individually. Okay, I can tell you some things that our law says it's not. So it's not beyond all doubt. It's not 100%, because if it were those things, would you be necessarily a juror on this type of case? Or would you be maybe a witness? right? To know something happened, you saw it happen, right? Possible doesn't always mean reasonable, right? You have to look at whether it's a reasonable possibility versus just a possibility. Is it reasonable? And the reasonable doubt, it goes just the elements of the offense, which we're going to talk about in a second. So I can tell you already that the color of the shirt of a witness is not an element of the offense. So if you have a reasonable doubt whether it was a blue shirt or a red shirt, so long as you think we've met the burden on all the elements of the offense, then your verdict should be guilty. Does that make sense? Right? So long as the doubt doesn't go to an element, then we're fine. Okay. So I like to demonstrate beyond a reasonable doubt our burden of proof. You think this picture. Who here has dogs? You've got your cards out. Who here who has dogs has come home, or let's say we'll narrow down to one dog. Has one dog and has come home to like a situation like this. Okay. I'm gonna number 23. Did you raise your card? Okay. So tell me what happened.
Almost exactly that same picture.
Really?
Yeah. Except for my dog ate around the trim of a refrigerator and pulled out a brisket.
Dedication. That's really expensive. Both the brisket and the fridge.
Yeah.
Do you know that your dog did it?
Yes.
Were you there to see it happen?
Nope.
But you know beyond a reasonable doubt it happened.
Yes.
Right? So I use this to demonstrate that you don't have to be there and see it happen for you to know beyond a reasonable doubt something happened, right? You have to look at all the facts, the circumstances surrounding a situation to know something beyond a reasonable doubt, right? Does that make sense to everybody? Does anybody have any questions on it? So, like I promised, these are the elements that the state has to prove beyond a reasonable doubt in this case. That on or about the 12th day, I believe actually wrong date in there, but a date. The defendant intentionally and knowingly caused the penetration of the anus of Marissa Elizabeth Gail Salazar, who sometimes we'll call the victim or the complainant in the case, by the defendant's finger without the consent of the complainant, and that the complainant had not considered and the defendant knew the complainant was unconscious and physically unable to resist. So I first should ask, does anybody know a person by the name of Marissa Elizabeth Gail Salazar? I don't see any cards. So a lot of these are not going to be like, I anticipate, are not going to be real big issues on the case, like the defendant's name, the complainant, or the date. But I'm going to talk about.
I'm going to object to this slide. It's an incomplete statement of the law and the elements part of the state.
All right, that'll be overruled.
So I don't anticipate a lot of these elements, again, are going to be, very hotly contested, like the date or Bear County or something like that. So I'm going to talk about some of the more, I think, will be bigger issues on the case as it relates to these elements. So the first thing I'm going to talk about is penetration. And I'm going to be pretty brief about this. Our law is that penetration, no matter how slight. So I like to think of this in the terms of, for our football fans, breaking the plane of the touchdown for the end zone, right? So long as you break the plane, then that's a touchdown, right? So penetration is however slight. There's not a certain amount that it has to be in for order of the state to prove that element. So long as there's a barrier that's been broken, then that's what penetration is. Any questions on that? So the next thing I want to talk to you is the date. It's alleged on or about. So our law provides that the state does not have to prove an exact date, only that the date was prior to the indictment being presented and within the statute of limitations, which is 10 years in this case. So what we have to prove to you is that the offense happened before the indictment and it happened within the past 10 years. Anybody can think of a reason why the law allows us to allege it in this way, allows us to proceed with cases this way? do. Let me ask you this question. Does anybody here, or is anybody here a victim of sexual assault or know somebody who has been a victim of sexual assault? Okay, I see a good amount of cards up. Out of those people who.
Can we keep the cards up?
Yes.
Okay.
And if you would just, if you could call out the numbers.
Okay. 2, 3, 4, 6. And once I call your number, you can put your card down. 8, 9, 13, 14, 15, 17, 18, 20, 21, 22, 23, 26, 27, 28, 31, 32, 33, 34, 35, 38, 39, 40, 41, 47, 50, 51, 53, 54, 56, 58, 59, 61, 63, 64, 66, 67, 68, 69, and 74. Out of those who raise their cards, who out of those victims immediately reported what happened? Outcried immediately about what happened. So I see, if you could flip your card, 8, 28, 34, 40, 59, and 66. So maybe thinking about that question, knowing that they don't always immediately outcry, are we always able to necessarily pin it down to an exact date? No. Right, so does that make sense why our law allows us to allege it in this way? At honor about. Does anybody have a problem with that being a law? That we don't, as long as we show that it was before the indictment and within the past 10 years, that's okay under our law. Does anybody have a problem with that? See number 74. Okay. So we want to talk a little bit about evidence type of cases. First thing is testimony is evidence. So a lot, I think probably a lot of us have seen a lot of crime shows, BSI and things like that. But unfortunately, that's not the reality of a lot of our cases. You're not gonna have a bunch of scientists coming here and talking to you about, I don't know, sand and fibers and whatever else it might be, right? But a lot of what you're going to hear and what is evidence that you can consider in this case is testimony. So when a witness takes a stand, they take an oath, and they can tell you what they have to tell you that's relevant. I mean, this is subject to the determination of the credibility, and I'm going to talk about that in a second. So, what kind of witnesses do you think generally we have in sexual assault cases? What kind of witnesses would you expect generally? Juror number 17. The victim, okay. Anybody else? Juror number 28.
Just someone who happens to be their relation or
Bystander, okay. Anybody else? Juror number 19.
Same what they said.
47, same, juror number 19.
is somebody who maybe they told like right after it happened.
Okay, so they initially outcried you. Anybody else? 34.
Police officers, medical staff.
Police, maybe medical. Juror number 59.
Possible and character witness.
Okay.
Possible and character witness for defense.
Okay. Juror number 75, if you can stand for me.
The victim's family.
Victim's family. Juror number 7.
Counselor.
Counselor. Where does what are these types of crimes, where do they usually occur? Everywhere? Do they usually happen out in the open?
No.
No. So ultimately, because the defendant gets to choose where and when these offenses occur and how they happen and who they happen to. How many people think we're gonna have necessarily multiple witnesses, meaning people who saw what happened, come testify? Get a lot of head shakes, no, right? Is that a problem for anybody? Might not be anybody else who was present who could say what they saw. I don't see any cards. Okay. So I want to talk about credibility of witnesses. So if you are so fortunate to spend the next couple days with us on this case, if you get the jury charge, it'll tell you that you are the sole determiners of the credibility of the witnesses and the weight to be given to the testimony. So what that means is if a witness takes a stand, you can believe everything of what they said. You can believe nothing of what they said, or you can believe some things that they said, and not some things that they said. But you get to determine the credibility and what you believe from that witness. So, what types of things do we look for when we're determining the credibility of someone we're talking to, whether that's a coworker, our kids, our spouses, our family? Juror number 47.
Their appearance,
Their appearance, okay.
how they present themselves.
How they present themselves. Juror number 20.
Previous experiences.
Previous experiences. Juror number 68. Same, okay. Juror number, if you can turn the 14.
Consistency.
Consistency, and I want to talk about that in just a second. Anybody else? Juror number 9.
Yeah, maybe if they have addictions like that.
Anybody else? Juror number 7.
If the witness has accused or been part of an accusation before.
Previous accusations. Juror number 28.
I would just say possibly what their occupation is, if it was police.
Okay.
All right, so I'm sorry, I'm gonna need everybody to speak up, and if you're not on these 3 rows, if you could stand, it'll make it easy for the court reporter to hear.
Okay, so from their profession might add to their credibility, right? Anybody else? Juror number 34.
State of mind of the witness at the time of the incident. What did they see and how was their mental capacity at that time? Were they altered? Were they clear? I think that weighs a lot as well.
Okay. 34. I'm gonna touch on that in a second. Juror number 51.
Any relationship?
Okay, relationships. Juror number 47.
Actually, I already have a question, with the PowerPoint, the last one that you presented, it says the witness or the, I'm sorry, the victim. So if she says that Mr. Perez did it, I already thought that she was unconscious. So I know there's different kinds of unconscious states, but if she already said she was unconscious, how can she point out Mr. Perez?
So
I'm not trying to like study it yet, but I just saw that the victim was unconscious, and it also says that she was not willing. But how can you be willing when you're unconscious?
Okay, excuse me, sir.
Yeah.
All of these are hypotheticals?
Yeah, I understand.
Yes.
But
All
I
right.
just saw that. I just
Okay.
kinda saw it.
Thank
So-
you.
So, we can't talk about the facts of the case. It's ultimately, we're gonna have to prove to death beyond a reasonable doubt. And there's a lot of different ways that can be proven, but I can't go into the facts about it. But that is something that we have to prove. Okay, I'm gonna go through some of the things that jurors have previously told me. Demeanor. Motive, I think kind of somebody touched on this, maybe family relationships. Do they have a dog in the fight? Do they have a reason to be saying something a certain way? Are they gonna lose something or gain something by testifying a certain way? What they say, does even what they say make sense? I think juror number 14 talked about consistency in statements. So I want to talk about consistency using this. This is a very San Antonio. I'm a San Antonio born and raised boy, so yes, it's near and dear to my heart. Who here has gone to any of the parades during gift time. Okay, see a bunch of cards up. So just a little bit like a story from my life is that I have good memories of the Battle of Flowers parade because my aunt and uncle used to always take me every year. It was always the same routine. We go to Church's Chicken, pick up some chicken. They had our spots already laid out. Once we got there, it was, you know, funnel cakes galore, turkey legs galore, everything that a large kid would want. And so I enjoyed going to the parade. Especially I'm a third generation Aggie, don't hold that against me. And so especially when the A&M band was there, I was always excited to see them. So let's use it this hypothetical. So let's say I go to the parade, I watch it from start to end. Who thinks I'm going to be able to tell you all of the floats that I saw, all the shoes of the duchesses that I saw, the order in which they presented, all of the bands, and to that degree of specificity? Who thinks I'll be able to recount it that way? See, a lot of heads, right? Now, I might remember some highlights. I remember the A&M band, I remember a certain pair of shoes. So let's say I tell my aunt or uncle after the parade, or let's say my parents, because they weren't. These are the floats that I saw, these are the shoes that I saw, and these are the bands that I saw that I liked. So who thinks me telling my parents immediately after the parade, and if I told them 6 months later, I would have the exact same details? I think a lot of head shakes no, right? Does it mean that I wasn't at the parade? Right? So sometimes there might be some changes in consistency that don't necessarily mean a person is being untruthful. Ultimately, you get to make that decision whether those mean that they're being untruthful or not. But I just use it to illustrate that it doesn't always mean that somebody's being untruthful. Got a bunch of sports fans. You don't figure it out by now, or you'll figure it out soon. Judge Boyd is a huge LSU fan. So let me give this as an example of football example. So there are 3 people at the same game. You have a spectator, somebody who's watching the game. You have a player, and you have a ref. So all of them watch the same play. Are they going to tell you exactly the same story about that play? Sometimes, right? So why might their stories be inconsistent with one another? 47.
Depends on the angle where you're at. If I'm directly looking at you, they might be on the side. We have different, fields of view or whatever. What you see is what you're gonna picture.
Right. They're different angles. Juror number,
Yeah, I was gonna say perspective.
Juror number 68.
Depends who they favor more out of the two.
Right. Judge is a very, very fair person. But if LSU is playing Florida, she might see it play a little bit differently than there's a defense trainer around here's a huge Florida fan. They might see the plays a little differently, right? Also, they might be looking for different things, right? Is a ref going to be looking at a play with the same objective as a spectator? No, right? They're looking to see is the play clean? What are the results of the play? And then a spectator's just hoping their team win, right? And also, I think somebody already talked about this. They have different biases already coming in to that, right? A spectator might have that. Does that make sense to everybody?
Yes.
So any questions about that? We already kind of touched on this, but do you think the people who always have been sexually abused or sexually assaulted reported to me? Why not? Juror number, people haven't heard from before. Juror number 2. Ashamed. Juror number 6.
Ashamed, scared.
Shame, scared. Juror number 7.
I get in trouble.
I get in trouble. Juror number 17.
Fear.
Fear. Juror number 21.
Yeah, fear, shame.
Fear, shame. Juror number 61. You can stand for me. I'm sorry.
Having released your uncle and with your relatives, that's what we saw. Somebody that's very
Okay, so if it's family, it might be more difficult, right? To report it.
All right, so everyone, please remember to speak up so the court reporter can hear.
Juror number 68.
Possible issues of the credibility compared to wonder even.
Okay. Kind of interpret that they might not be believed. Juror number 62. You see it for me?
I was gonna say the same thing as her family or anybody or harmed by that person as well. So they're just gonna speak up.
Okay. Juror number 75. They're not believed. Juror number 14.
Denial.
Denial. Juror number 8. The anxious and anxiety from being able to speak up. Juror number 9.
Actually, some people don't even realize they've been sexually assaulted until after the fact. You know, they, especially if there's an unconscious situation in life here, they may not realize that they would not give consent.
Okay.
They were in an intimate situation with somebody.
Juror number 28. You could stand.
They may think that the situation that they were in basically put them, that they're just guilty of being in a bad situation.
Right. They
It
might
was
take,
their fault as
they take some of that blame on themselves. Okay. So I'll move on just a little bit. So if the sexual assault is not reported immediately, do you think we are necessarily going to have any physical evidence like DNA? A lot of no's. During 45 year product?
Yeah, it depends. They reported some previous later. After the trial.
Okay, so it might depend, right? What also might change whether or determine whether we have or there would be DNA or some type of physical evidence that we could have. Turn number 34, you can see anything,
Bathing, showering, changing clothes.
all of those things. Anybody else? Turn number 2. Right, the nature of the assault, like as alleged in this case, a finger penetrating somebody's anus, is that necessarily going to leave any type of physical evidence?
Aaron, I would object, it's leaving too much in the effect.
All right, ladies and gentlemen of the jury, all of these questions that the state are asking and that the defense are asking, these are all hypotheticals. They have absolutely no basis in facts in this case. You will only hear facts in this case if you're selected on the jury. Does everyone understand?
So again, we showed you all the elements of the offense, what the state has to prove to beyond a reasonable doubt. In this case, it is a finger penetrating anus. Do you think that type of penetration or contact would necessarily leave a bunch of DNA for us to test? I hear yes. Who said yes? Go to jury number 61. Anybody agree with 61? 58. 74. 75. That they believe that a finger penetrating anus would leave a sufficient amount of physical evidence like DNA or something like that.
I'm gonna object, these are bordering on improper questions about certain.
All right, that'll be overruled.
So again, anybody agree with it was 61 originally said yes? Anybody agree with that? Who hasn't raised their card already? I got you 74.
I think it could depend on how much time has passed.
Thought that was judge for a second. So, anybody require the state to present DNA evidence before you could find someone guilty of a sexual offense, even if the other evidence proved to you beyond a reasonable doubt? Anybody require the state to put DNA evidence? Juror number 68 and 4. Anybody else? So if we don't say it's again a hypothetical. We don't have any physical evidence. It's not immediately reported. How do we typically, you think, the state proves these cases to you? To jurors. Juror number 9. Testimony. Right? There might not be any eyewitnesses, there might not be any physical evidence, so you might, the only witnesses who actually were there, you might hear is the victim. Is that a problem for anybody? Let me ask it a different way. Should we prosecute sexual assault cases if we only have the word of the victim? Who disagrees with that statement? Who thinks we shouldn't, rather, prosecute sexual assault cases if we only have the word of the victim?
He said should.
Don't look at the slide. I know I'm asking it in the opposite way. Who thinks we shouldn't prosecute sexual assault cases if we only have the word of the victim?
He said shouldn't or should?
Should not.
Should not.
Good. If you could turn your card around.
Oh, sorry.
I saw, I see 47, 48.
Well, before, a question, by prosecuting, you mean going through the process?
What we're doing here
Or, okay, no.
Okay. During 51 and 56. Okay. So this is a scale question. You have to fall into one of these categories. You might say, I want to follow one and then two maybe, but which one of these do you more identify with? So the question is, if only one person testifies, that is not enough to find someone guilty. Option number 1 is strongly disagree. One witness is enough, it's believable. 2 is disagree. I will decide based on the testimony. 3 is agree. I want more. And 4 is disagree. I need more. For instance, give me a second. I'm gonna do one more.
Oh, sorry.
So again, the question is, if only one person testifies, that is not enough to find someone guilty. Option number 1, strongly disagree. 1 witness is enough to believable. 2, disagree. I will decide based on the testimony. 3 is agree. I want more. And 4 is strongly agree. I need more. Do you have a question, 47?
No.
Okay.
Like I said, I had that clause that I saw, so that's probably agree it's not enough.
So what I'm gonna do is I'm gonna say each one individually, and if you identify with that one the most, then please raise your card. So who falls into category number 1? Strongly disagree. 1 witness is enough if believable. I see 5, 2, 6, 14, 14, 31, 39, 40, 44, 45, 58, 72, and 74. Did I miss anybody?
I misread that then.
And then the question.
Just 1 second. I'll get you. 47, you fall into 1?
Yes, I misread it.
Okay. 22 are you? I'm gonna come back to you. Juror number 9, question.
But yeah, you said 1 witness is enough. In other words, if the testimony is a credible witness, that's what that means.
Yes. Juror number 9. Juror number 22. What's the question?
I'm sorry. no.
You can stand.
If one person testifies, that is not enough to
That-
find someone guilty. Strongly disagree. 1 witness is enough.
So that statement, and what would your response be? Only 1 person testifies, that's enough, not enough to find someone guilty. I strongly disagree with that statement. Or I disagree, agree, or strongly agree. I'll come back to you. Okay. Who falls into category number 2? Disagree. I will decide based on the testimony. Okay, I see 1, 3, 7, 8, 11, 12, 15, 17, 18, 19, 20, 21, 22, 23, 24, through 28. 32 through 35. 37, 38, 41, 42, 43, 46, 50, 53, 56, 57 through 64, 66, 67, 69 through 71, and 75. Who falls into category number 3? I want more. See, 4, 10, 36, 48, 51, and 68. And who falls into category number 4? Strongly agree. I need more. 47, you're changing.
Yes, because I have to read it. It says, so one person, that's what it means, right? One person alone. Yeah, I need more.
47. 54. Fair number 22. Are you able to make a decision? Okay. I can't remember what numbers I called. I'm good. I'm not back there. Okay. I'm going to skip this one for now. So I want to talk about alcohol or intoxication because sometimes these issues come up in these types of cases. So first, what I want to talk about as far as it relates to the defendant is that all the law says involuntary intoxication is not a defense. Which is pretty clear in our code about that. So if an accused voluntarily intoxicates themselves, it is not a defense to prosecution. Does that make sense to everybody? So like, I was drunk, I didn't mean to do it. I'm drunk, I don't remember. That's not a defense. So, and that's very poor worded. Clearly, I didn't read that before I put it on the slide. It should say, might alcohol or intoxication affect a witness? Yes. What types of ways? Sure, number 40.
Ability to perceive and recall facts.
Okay. Sure, number 17. Memory loss. Number 21.
Judgment.
Judgment. 8. Yes, if you could speak up for me a little bit. Very soft.
What if it was peer pressure?
So voluntary intoxication can be under peer pressure or anything like that. If you make a decision to intoxicate yourself, then it's not a defense. But are you asking as it relates to my alcohol affect the witnesses? Affect the witness? Does the fact that someone is under the influence of alcohol or intoxicated automatically make them not credible or change their credibility? Juror number 20.
Depending on the situation,
Depend-
time frame, how long you were drinking.
Okay, thank you. Will, juror 21.
Yeah, same thing, time frame and also like the strength of whatever they were. They were just like a drink or two, or they're a little buzzed, or they're just wasted, like high blood alcohol level, something like that. That'd be different.
Okay. I think it depends for a lot of people, right? Is there anybody here who thinks, well, if somebody is intoxicated or under the influence of alcohol, I'm automatically not going to believe what they said? I see 47, 48, 54, 56, 68, and 75. Is anybody? So, like I said, we'll just talk about punishment. Because if you find the defendant guilty, then you would have to determine punishment in this case, if you're on the jury. So for sexual assault, it's 2 to 20 years up to a $10,000 fine. And probation is a possibility, so long as the defendant has never been previously convicted of a felony, and that you assess the punishment at 10 years or less. Kind of weird, like, well, if I'm assessing punishment at 10 years or less, if you decide to give probation in these types of cases, you still have to assess an underlying sentence. Meaning, I want to give them 10 years, but I want them to put them on probation. but just an underlying sentence. So, kind of weird how our law is, but that's how it is, that you have to, regardless of whether you give him probation or not, you have to set an underlying sentence. So, Judge talked about our range of punishment and their ability to follow the law as it relates to the range of punishment. So I like to think about it in this way. Participating defense will also talk about this with you a little bit. I think of range of punishment like I think about so we have a little story about myself. I'm probably sure this shocks you, but I'm a mama's boy. So I had, before the pandemic at least, a standing lunch date with my mother every Saturday. And it was at this restaurant. Hopefully you've been there because it's amazing, China Inn. And so we would go there every Saturday. I was always going to order the same thing every time I got there, but I don't know who I was pretending. I would still get the menu. I would still open up the menu. Gary was usually our waiter. But I would still look at the menu every time. Am I gonna get, I'm sorry, Diana's probably gonna hate me for using words she doesn't have keystrokes for, but I'd always get kung pao chicken and fried rice and egg roll. So punishment I like to think about is opening up the menu and looking. That's all we're asking you to do. Just take a consideration. Means that once you hear the facts, well, I won't ever give 2 years or 10 years. I would never give probation based on the fact, but you have to be able to at least say, I would consider it. So what we're asking for you to is to, even though you might like lean one way, like I don't think I could give probation on these types of cases, or I don't think I can give prison on these cases. All we're asking you to do is to open up the menu and look. Does that make sense to everybody? Right? It's not whether you would give something, it's whether you can consider something. And it doesn't mean that I might lean one way or another. It's just, can you consider? So, from what I understood from the judge on her opening, that nobody has an issue with anywhere from probation to 20 years, right? On these types of cases. Everybody can consider the full range of punishments. Am I understanding that correctly? Juror number 28.
I could consider that if I found someone guilty on something, I don't know that.
So this is one of the areas of law that I have to get an answer from you one way or another. It's like pregnancy, like you're pregnant or I got your nails down to a fun answer. And you're saying, I don't think I can consider it. I'm not asking for you to find the exact situation in your mind that, oh, well, I could maybe consider it on this. All I'm asking is that when you get back there on punishment and find somebody guilty of this, I would at least, I would consider, I would say, could I do probation? Okay, based on the fact that I couldn't do probation. And then you can move on from there. All you have to do is be able to consider it. Doesn't mean that you're going to get it. Does that make sense? Okay. Does that change? Okay. Would you be able to consider the full range of punishment?
I'm sorry,
She said, yeah. You said yes, right? All right, anybody else? Juror number 68. Could you consider the full range of punishment? Does that change from what the judge talked about?
Yes, it changes.
Okay. So you would not be able to consider the full range of punishment?
No, unfortunately, based on that, I'm a strong believer of punitive punishment.
sorry, sir, can you speak up louder, please?
Listen, I was just saying, I'm a strong believer in incarceration as punishment, punitive punishment.
Okay. All right. So this is another scale question, and it's just kind of gets a quick snapshot from you. So, what is the purpose of sentence of a sentence? Number one is punishment. The defendant needs to be punished for the consequences of his actions. Or 2, rehabilitation. I need to help the defendant from reoffending. So, a lot of people, I'm a 1, but I have a little bit of 2 in there too. Like I think it should be punishment, but there should be some rehabilitation. I think we're all a little kind of on that spectrum. What I'm asking you to do on this is which one do you more identify with? Not that you completely identify with it, but which one do you more identify with out of the 2? So again, what is the purpose of sentence? Number 1 is punishment. The defendant needs to be punished for the consequences of his actions. Or 2, rehabilitation. I need to help the defendant from reoffending. Who falls into category number one, punishment? I see 3, 4, 6, or 12. 15, 17, 18, 19. Do you have your card up? 23 through 28. 31 through 35. 37 through 48. 50, 51, 54, 56, 57, 58, 60 through 64, 67 through 69, 71, 72, 74, and 75. So this falls into category number 2, rehabilitation.
There's also prevent.
I mean, there is a prevention deterrence, right? There's some different schools of philosophies in relation to this, but I'm just asking about. which one-
15 minutes.
Thank you, Judge. Out of these two, which one do you more identify with? So who falls category number 2? 1, 2, 14, 20, 21, 22, 36, 53, 59, and 70. And thank you, Judge. So, I'm gonna go through some final questions for you. Does somebody screwed the file? I know it should say anyone, no, anyone who's been accused of this crime or a similar crime, a type of sexual offense. I gave cards. 2, 15, 27, 34, 38, 40, 41, 42, 47, 61, 63, 67, 68, and 72. So out of those people who raise their cards, who know somebody's been accused of this crime, were put through the criminal justice system. And I'm not showing cards necessarily for that, but if you know somebody's been accused and was put through the criminal justice system, is there anybody who raised their cards who felt like they weren't fairly treated throughout the process? 42 and 34. So out of those two, 34 and 42, having that or knowing that person, would that affect your ability to be a fair and impartial juror on this case? No. Juror number 42 is no. Juror number 34.
I don't want to be the one. But given my professional background and the things that I've seen, I have to deal with same exams, sexual abuse, nurse exam. To be fair to all the parties involved,
That's what we want.
I think for the defendant, I couldn't say I could totally be impartial. Given the situation, and granted, I don't know all the details, but at least what's being presented for Mr. Perez's sake. I like to be fair to both, and I can't truly say it would be fair.
Fine, thank you. Anybody else? Does anyone know anyone who or who themselves might be a victim of sexual assault? We had those cards before. I don't need you to raise them again. We went through those. But out of those people who are victims or know a victim, does anybody feel that the victim, if they went through the criminal justice system, was treated unfairly? They have show cards. Juror number 68, thank you. Out of those people who, again, raise your cards kind of early on in my presentation, who are or know victims of sexual assault, would that affect any of your abilities to be a fair and impartial juror on this case? That could get a show of cards if that applies to you. Okay, juror number 9, 47, 54, 56, 38, 28, 58, 61, and 68. And so what we have to do, and again, going back to fair and impartial jurors on this case, meaning, again, these are people who just raised their cards. What we're asking from you is saying, this thing might have happened to me, or I know somebody, and it affected them. But I know that this case is independent of it, so I'm going to, what I can, put those things aside and look at the facts just of this case and the law that the judge gives me, and then render my verdict on those two things. Does that change the answer for anybody? I can put those things aside and just look at the facts on this case and the evidence on this case and the law the judge gives me and just base my decision just on that. Is there anyone who, I've just kind of talked about this a little bit, I'm not worried about time constraints. What I'm worried about is health reasons, hearing issues, things like that, who they don't think they can sit on this trial because of those things. Juror number 4.
I won't be able to think about this trial because I'm gonna be busy thinking about feeding my kids or paying my rent because I can't miss any days, let alone 3.
All right, so let me just stop everybody there. The people who are like, I need to go because I need to work, or there's somewhere else I need to be, you need to be here. Because we cannot have juries without jurors. And this is the only thing that your government is asking of you. You may continue.
I have a question for that, man, because, you know, I understand the jury and he's a jury. My kids and my wife.
I've spoken. Thank you.
Like, I had to speak to my wife last night because we had to make a decision whether I even showed up today because she's heavily pregnant, she can't work. You know,
I've spoken. Thank you. State, ask your next question.
So again, if you have your cards and it's a work issue, judge has already kind of explained. So talking about like health issues, hearing issues, things like that. Juror number 9.
Yes, sir. I have 3 herniated discs in my lower lumbar, my back. It makes it very hard for me to sit for more than an hour and a half.
Okay.
I'm standing for an hour.
Generally, we try to get people regularly, even so that I don't anticipate should be an issue. Anybody else? Juror number 33. Hearing. Have you been able to hear everything we've been talking about today?
Somewhat.
Okay. Is there any portion that you didn't hear?
Bits and pieces of it, but I can read lips.
Okay. And it's a little different. We have everybody usually mic'd up during trial, so we don't have portable mics, so that hopefully shouldn't be present to be an issue. Juror number 66.
I have my hearing aids turned on, they're assisted hearing as loud as I can. They're not looking at me.
Okay.
When you walk around to address other people, I'm listed off.
Okay. Okay. So you actually have a hearing device with you?
Dude, I'm wired for sound.
Okay. Okay, if you could just stand for me, just repeat that. From what I'm understanding, you have a hearing device with you. It's on the maximum volume, and if right now you're having trouble hearing everything, especially when I'm not facing.
Exactly.
Okay.
And when a judge is speaking, most of the words I could get, but not all of them, because the camera quality isn't that good for me.
Blame the county, okay? There's our equipment, sorry, but I thank you for your honesty, and thank you for letting me know. I wouldn't have known. All right. With that, I am going to give Judge back some of her time. I appreciate everybody here talking with me. I look forward to spending some time with you in the next episode. Thank you, guys.
Right, defense. All right, we're going to take a 10-minute break, everyone. So I'm going to need everyone to make sure you're lined up outside, and we'll be back at 12:40. So everyone, please rise for the panel. Yes. Everyone, you're more than welcome to leave your items behind at your seat. But everyone has to leave the courtroom.
Judge. My family can we come to your house?
And please leave
I'm
your.
sorry,
number.
what?
My family's not able to eat next week. Can we come to your house?
You can get a job.
I have a job.
You may
That's
leave the
what I'm
courtroom.
trying
I'm
to
not
do.
listening to your nonsense. You can step out of this
It's not
courtroom. We will
nonsense,
be
but
back.
like my
We will
personal
be
feelings
back.
to my family.
Excuse me, Deputy, could you have him go outside, please? I'm not gonna have this
Thank you for
situation
your-
where people
thank
are
you so
trying to
much.
get out of jury duty. That will not happen here.
Trying to.
That will not happen here. Step outside.
I would actually like to serve
Step
jury.
outside.
I cannot afford it.
Step outside.
I don't care about it, but. we're
Step
free-
outside. I do
free
not want to
labor
hear from
here.
you
Free slave
again.
labor.
I do not want to hear from you again.
He took the number.
All right, everyone. We'll be back. Thank you.
And Judge, he was the one from yesterday.
Okay.
He was the one that was
Causing issues.
causing everything.
No problem.
Pueden salir para afuera, pero no pueden hablar con nadie.
He was the one that was causing the disturbance with everybody else, like, oh my God, it only takes one. It only takes one.
Mhm. You know, I don't know why people don't want to serve on jury duties. I know he used to wait outside and he used to come back. Thank you. Oh, yeah, no. Once we bring them back in, he's coming back in. All right, thank you. All right, yes. Mhm. Oh, no, we'll do it today, but we're gonna do finish with jury selection and we're gonna go from there. Yes. No, if you want to send someone else, you can. All right, because they have another hour. Defense has an hour for their selection. So that will put us at about 1:30. If you want to be back at 1:30, we can do your motion then. Yes.
Okay. 1:30.
Yeah. I don't know why people try to get out of jury duty and then it's, I mean, we have jury trials and people need to be here for jury trials. And he had a chance to review that with whoever qualified him to be on this panel. Oh, just one second. I have to change the thing. Just give me a second.
Oh, is that?
Yeah, he needs to publish, right?
Yeah, but I'm trying to follow up. Like my guy.
And is that one working? Because I had one up here, but I think it's been moved to hers.
Which one are you trying to do?
What are you trying to do?
It's on.
You can show it on the screen.
No.
Oh, oh, that's gonna be
Because I don't have, it was up here for me, but they moved it. All right, let me ask you this. Are you able to move it to, are you okay with moving it to their system? or not?
Ours is not
I don't mind if there's a
like, it went off on the very end of my presentation. I don't know what.
Yeah.
I didn't.
Okay, awesome. You're welcome.
I wonder if why that high.
Mhm.
I wonder if my arm would have powered back. On the stand, the shepherd wall.
No, it's on.
No, try number 4 is a pirate. Three. Oh.
So do we have it ready or no?
No, he's checking to see if it's connected properly.
Don't be anything that was.
All right, somebody want to call IT? I'm assuming you want to use the,
Yes, right.
all right.
How do y'all hook up to?
I don't see anything unplugged down here.
All right, and so state yours is not operating either?
Yeah.
I'm gonna try there.
Oh, now ours working.
Okay,
You want to just put it over on mine?
When you say put it on there, you mean the file?
I can just play it from your flash drive.
I have it on the flash drive. It's on the computer.
I have a flash drive if you want to put it on a flash drive,
Yeah.
and like you can watch me delete it afterwards.
Okay.
We're gonna.
okay.
Have a flash drive.
All right, thank you.
You're pushing my technological knowledge. to its limits.
And while they're doing that, could you have juror number 4 come in, please? No. What is your name? You're too close. You need to step back. Mr. Guerrero, I want to be clear about something, and could I have people please be quiet? I will not tolerate disrespect in this court. I will not tolerate disrespect to the court or to me. I will not tolerate a disturbance in this court. You have been brought up on this panel. If there were any other issues, you needed to bring them up with the judge who was qualifying you. I will not allow you to cause a disruption or a disturbance to this jury trial or infect any of the other panel members. If you continue causing a disturbance to this panel and a disturbance in this court and showing disrespect to the court, let me just tell you what's potentially could happen. I will hold you in contempt. The minimum fine for contempt is $500 or either 6 months in jail. Do you understand? All right, thank you. You can step outside. You're talking to the judge right now. They qualified all the jurors who appeared here. You may step outside. I will not tolerate any further disturbance from you. All right, defense, are you ready to proceed?
We are, Your Honor.
All right, are both sides ready to proceed?
Yes, I just think that the interpreter had a question about timing. I don't know if there needs to be a
Oh, no.
replacement.
Oh, do you need a replacement?
They asked me at the office, Your Honor, if there was gonna be a lunch break for the switch of the next interpreter that is coming. I want to be.
Oh, no, there's going to be, after defense finishes, I gave each side an hour. So after he finishes, there will be a lunch break.
Okay, all right. So I'll tell them that so that I don't have to interrupt switching to another interpreter.
All right, thank you so much. All right, everyone, please rise for the jurors.
No, no, no. It's perfectly fine.
All right, everyone, please be seated. Defense, you may proceed.
Thank you, Your Honor. All right, it's afternoon now, so good afternoon, ladies and gentlemen. While you guys were out, we had a little technological snafu and it's pushing the limits of my technological knowledge, so please bear with me. A lot of the things that they've already spoken about, I'm just gonna touch on briefly. You know, every prosecutor has their own style and way of doing things. And it looks like, from what I hear, one of the things I like to talk about, if you look at the screen, is the importance to tell the truth. During this process right here, it looks like you guys are handling that very well. I think part of that is trying to elicit from you guys information that if you guys have a problem with the type of case, the type of accusation, anything of that nature, please feel free to come forward, okay, and raise your hand about that. I'm going to ask a general question about, some of you have had contact with the legal system before, whether it be a civil trial or a criminal trial. And could you raise your hand and your number for that? Okay, I'm going to go backwards because since I'm over here. 71, 72, 54, 56, 47, 50, 44, 40, 42, 36, 34, 27, 25, 23, 20, 15, and 6, and 2. Yes, sir. Has anybody here, and I noticed in some of your questionnaires, you mentioned that you had contact with the legal system before, whether it be a civil case or a criminal case, number 8. And I'll just ask one quick follow-up with that. Is there something in the process that you guys experienced that soured you on that process? Either bad lawyer, bad judge, bad set of facts, didn't like what the process was about. Anybody soured on that process? Number 36, and I'm actually going to follow up with you a little bit later. And the second one over here, number 34. Number 8. Okay. And I noticed a few of you, that includes, and I don't know if I was clear on this, whether you guys were jurors or not. A bunch of you guys were jurors, and it's in the questionnaire. Is there anybody that can take from that experience a negative experience, something that soured you on the legal system because you were a juror and based on that participation? Very good. The judge talked about this earlier, and you know, this is not a process where we're going to ask you to do something extraordinary. You're basically here, and your job as a juror is to judge the evidence before you, right? The facts before you, whether it be through scientific evidence, whether it be through testimony, whether it be through exhibits, whether it be through anything that the prosecution intends to introduce to you. And that is your sole job. If you're concerned about knowledge of the law, if you're concerned about issues that he and I have, the judge takes care of that, okay? And you may have seen me already stand up and object. And I'm going to point out one of the things that the prosecution must prove, and that is that this case took place in Bexar County in the state of Texas. Right? And you think to yourself, of course, we're here. But everything that they must prove, and he touched on this, must be proven beyond a reasonable doubt. Every single element. So I'm going to ask you this question. If you go through this whole trial and you never hear any testimony about the county of Bexar or the state of Texas, and I argue to you at the end of this, you've not been given any evidence that this took place in Bexar County. What must your verdict be? Who said it? Yes, sir.
Not guilty.
Not guilty.
There's nothing.
And just for the purpose of the record, I would object that then you proven by preponderance, and so it's not the same standard, but I just, as a matter of law, that's the correct law.
All right, defense, you may proceed.
So that is correct. What concerns me is that only one person said it. And I bring that up because I want you to understand that every single element of this crime must be proven beyond a reasonable doubt. And if they fail to do that, even something so, I'm sorry, must be, there must be some evidence to prove that. And if you don't receive that evidence,
you must find that person not guilty. Why is that important? Because that shows you the importance of the process that you're here to do. There is one part that is kind of extraordinary about your role. And that is we are asking you to take yourself out of your day-to-day situation. How many of you have kids? How many have been in a situation where somebody did something wrong and you're not exactly sure which one did it? Right? A whole bunch of us. How many of you ask for proof beyond a reasonable doubt? 1, 2, 3, right? 4, 5. But most of us don't, right? If those are not terms that we deal with on a daily basis, those are not things that we use in daily life. However, we're going to ask you to take yourself out of your daily situation, and legally you must use them in this case. As the court said, the information, the indictment in this case is just a way to start the proceedings, right? It is a formal document that accuses somebody of a violation of law. Okay. And that is not evidence. Okay, basically, it is an introduction by the prosecutor as to what they're going to show you, what their burden is to prove. Okay. Now, I spoke a little bit about burden of proof, and I got off of my slide here a little bit. But what is the purpose of having such a high burden of proof on every single element? Anybody know that? Why do we have such a high burden of proof on every single element? Absolutely correct. To prevent somebody that's not guilty from being found guilty, right? I'm sorry, you actually said it better than I did. But that's the perfect reason, right? Because we're not dealing with parades, right? We're not dealing with accusations against our children. We're not trying to find out who spilled the trash. Okay. The difference is real. What we're asking you to do is to place judgment on somebody and potentially send somebody to prison for up to 20 years. Can anybody see how that is much different than what we do in our daily lives? Okay. Does anybody disagree with that? Does anybody think that the prosecution shouldn't have that high of a burden? We're gonna forgive them a little. We're gonna give them the benefit of the doubt. Does anybody believe that? Good, because the answer is they can't have the benefit of the doubt. In fact, they have the opposite. We have the presumption of innocence. Every single citizen of the United States has the presumption of innocence. Okay. Does anybody know why we have the presumption of innocence? We have the answer. Yes. Not just government, but who else? Okay. Because the consequences are so high, because you're fighting the resources of the government, right? Because this is America, right? If the government is so certain that you committed a crime, people way smarter than us, back hundreds of years ago, decided this was going to be our system, the very best one in the world. If somebody's going to be put to trial, you have to prove this case beyond a reasonable doubt. Every single element. The person enjoys the presumption of innocence. 0. We're starting at 0 right now. Who believes that they've already heard a little bit of evidence in this case? 47, 54, 36, 42, 56, 38.
I'm sorry, 36.
58, 72, 75, 51. The answer is you have it. I'm sorry, who here? Number 6. The answer is you have it. This is just jury selection, right? And so the correct answer is we have not heard any evidence. The correct answer is there is zero information against this accused person. That's what the correct answer is. So this gentleman over here talked about government and potentially government putting accusations on. You know, we're not here to drum up some conspiracy theory that the government is bringing up false evidence. That's not what we're doing here. But there are mistakes, right? If we study law, if we study criminal law, as Michael and I have both done, we know that as time goes on, our process gets better. Right? Sometimes I look at these old cases, you know, things back in the old West, where somebody is accused of shooting somebody and they find him guilty. And to me, I'm like, how'd they do that? Right? They didn't have DNA. They didn't have fingerprints. They didn't have scientific processes. Right? So nowadays, we use all of those things to get better results. Right? Anybody here watch things like Dateline, 48 Hours, things of that nature? And a lot of the stuff educates even me, right? Because they handle all kinds of cases. They use all kinds of forensics. And what's the difference between a case that has a lot of forensics and a case that has no forensics? Yes, sir. Number 20.
They give you more clues to follow, I guess you could say, if you have.
Number 54. More clues to follow.
They don't get solved. They don't get solved.
They don't get solved if
They don't have.
they don't have enough forensics, right? Because what can you say about forensics?
It helps.
It helps. Or, you know, Michael was talking about DNA and, you know, what would cause you to have DNA or not DNA. The reality is, we don't know. Right? Who would know that answer? How about a DNA expert? Okay, we're just guessing. If we as people believe that we know more than the DNA expert, then there's issues, right? But in general, the person that knows how DNA gets transferred, how much DNA gets deposited, who is positive, who is negative would be who? The professional, right? And so that is for you guys to decide once you hear the testimony of a professional, whether that helps you in your case or not. So again, let me go back to the example that he was giving. Well, do you require DNA evidence? The answer of the law says you don't need DNA evidence. But what does DNA evidence give you? Facts. Correct, right? How about certainty? Right? We've caught serial killers decades later because we could prove by DNA that it was them. Let me give you an example. It's actually a terrible example, but it's one of the reasons that I do what I do. I went to law school in Austin, and there was a case while I was in school of a guy who was trying to appeal his rape conviction. The person in the apartment complex who was raped identified him and said that he was the one that raped him. And he spent, I think it was 2 years in jail, waiting trial. When they finally tested the DNA, when they got the results back, guess what? It wasn't him. It was another dude that was a landscaper that was working at that apartment complex. It kind of looked the same. So our processes are getting better, right? But if we had no DNA, if we had no testimony, if we didn't have that science at the time, she was ready to swear under oath that it was him, that it was his face, right? And so the law doesn't require that they provide DNA, but it certainly helps, doesn't it? It certainly gives you some certainty about what we're dealing with. Is there anybody here that doubts the science of DNA? Presumption of innocence, I already spoke about that. The right to remain silent. Okay. Along with some of the other rights that we have in the United States, it is the right to remain silent. In my experience, I can assure you that there are a lot of people that do not take this seriously. They believe that talking, that giving their opinion when they're accused of something is the best way to resolve things. Does anybody believe that if somebody who is accused of a crime, they should take the stand, they should testify, they should give a statement? Anybody believe that? Number 6. Number 9. So you believe that in spite of what the Constitution guarantees us, you would require somebody to take a stand in their defense. Okay. And if the law requires you not to have that standard, would you follow the law or would you go with your instinct? So if the law tells you you can't use that standard, are you telling us that you can't follow the law, or are you telling us that?
No, I can follow the law, but my personal bias thing is that my head, I could provide.
Very good. Anybody here, let me ask these first 3 rows, know why that's a bad idea? Yes, ma'am. So, yes, sir.
Because incriminating yourself.
Could be incriminating yourself. Not necessarily. What if you're not a good speaker? Right? What do you stutter? What do you get anxiety? What do you get nervous? Are those good reasons to find somebody guilty?
Yeah. Yes. Yeah, just, I mean, body sweat, all that, they all look at that, so like a 48.
So for you, that would be sufficient to find somebody guilty.
Yeah, if they're nervous, tapping, like we all are habit creatures. Sometimes people can't stop tapping, but if excessive sweating, excessive tapping, nervous, shaking your leg, that could be anything.
Okay. So anybody else here that believe that's enough to find somebody guilty? Anybody here really confident in their speaking abilities?
Confident in their speaking ability.
Speaking abilities, yes. If you guys seen My Cousin Vinny,
Yes.
going with him? You remember the public defender? When he stands up and he said, "I got this." And he stands up and he just starts stuttering like crazy. Right? So we don't know. Actually, we don't know until we're actually put under pressure as to how we're going to react. I suspect that the vast majority of us are not great public speakers. Right? So the burden of proof, the state has the entire burden of proof. I could sit down here after they put on their case in chief. I could remain silent. He could remain silent. And the law says that if they have not proven every single element beyond a reasonable doubt, you must find him what? Not guilty. Doesn't matter if you're suspicious, doesn't matter if you think maybe something happened, doesn't matter. Until they prove this case beyond a reasonable doubt, you must come back not guilty. The burden never shifts to us. You should never look to us to prove our innocence, because that's not the standard. Anybody disagree with that? All right. Let me get to the, as my good friend Nacho Libre would say, the nitty-gritty of all this. These, Michael was correct. There is no definition for beyond a reasonable doubt. But there are definitions for levels of proof in front of and behind it. Okay. So when you have no evidence, which is the situation right now, you must find an accused person not guilty. When you have a scintilla of evidence, That is any evidence at all, even the smallest amount. Right? You must still find somebody not guilty. Anybody disagree with that? If you have reasonable suspicion, and I'll bundle these together, which often leads to probable cause, and that is the standard that police officers use whenever they stop you. Right? They have to have visual confirmation that a crime has been committed. Okay, somebody running out of the gas station with a gun. What does the cop do? Does he have a trial right then and there? No, we want to give him the ability to enforce the law, stop people and ask questions. So that is reasonable suspicion that a crime has been committed, and probable cause to detain. That's a power that we give them. So the result is you get arrested. Does that mean you're guilty? No. Okay, does not mean you're guilty, because what if the guy was running out because somebody was shooting him there? That was his personal weapon. Right? At that moment, you don't have enough information. But what you do not want is you do not want a citizen running around waving guns. Right? So a cop gets to stop them, gets to possibly handcuff them, ask questions. Clear and convincing evidence. Clear and convincing evidence is exactly what it is. Evidence that is clear and that is convincing. It is a higher level of proof, and it is that level of proof. I'm sorry, I skipped one. Preponderance of the evidence. That's something that Michael brought up earlier. Preponderance of the evidence is the scales of justice, the 50-50. Right? If one party gives you information that's 51% and one gives you that's 49%, who wins in that battle? The 51, right? That is the level of proof for a civil case, for a car accident, for a dispute amongst money, contracts, wills, divorces. Okay, the law gives us a higher level burden of proof because what's involved in there is the loss of money, the loss of privileges, right? The loss of property potentially. And so you have to prove by a preponderance of the evidence whether you should win or not. That is not the case here. In that situation, if they prove to you by a preponderance of the evidence that something happened, what must be your verdict? Anybody? Not guilty, still not guilty. I'm going to jump to clear and convincing evidence. It's also a legal standard, and that is the legal standard that people within their office must prove to a jury before they remove children. Right? In certain abuse cases. That involves child protective services. Why is the burden so high? Let me ask you one. Why would, yes. Because of the consequences, right? Could you repeat your answer, ma'am? She said because of the children and then the consequences. Because we do not legally want to give the government the power to remove someone's children unless they show you by a high level of proof, right, that those children need to be removed from a house. Any questions about that? So if they prove to you by clear and convincing evidence that something may have happened, what must your vote be in this case? Still not guilty. Because the highest level of proof remains, and that is guilt beyond a reasonable doubt. Let me pick on somebody in the second row. Do you understand, or anybody give me a reason as to why the burden is so high? Anyone in the next row? Because the punishment, the results, right? One is losing your kids, the one below that. The other one is losing your freedom. Right? It's the same burden you and I and prosecutors, and anybody else that's facing potentially losing their freedom would want the government to show you. It has to be that high because mistakes are made. right? Because there's a high potential that maybe in the future, there's a separate technology that's even better than DNA. Right? And we have to hold the government to the very high standard with the tools that are available to prove somebody's guilt beyond a reasonable doubt. Anybody in the first row does not agree with that or have issue. Second. 3, 4, 5, 6, 7, 8. This side is first row. Second row. Third. Fourth. Last row. Ma'am, have you been able to hear me?
Sorry,
Have you been able to hear me?
part of it.
Part of it. Okay. Wave your flag if you haven't been able to hear. The judge asked a question early on about the interpretation, and let me just be clear. It's not that there is a misunderstanding of the English language. It's just that this is a complex process, and we want to make sure that everybody understands every single term, right, in their original language. So in the abundance of caution, we're doing this right here. Okay. Anybody have problems with that? So I think Mr. Villarreal was using an example early on in his voir dire about what you expect from somebody as a witness. You know, what if they have perfect vision? What if they're really close up? What if they're firing on all cylinders and they witness a crime? What does that make them? An eyewitness. Not just an eyewitness, what quality of eyewitness? A good one, maybe even a very good one, right? I can assure you if I do this, I cannot see a thing. I see smudges and blurs. So what does this make me? Yes. But with respect to quality of witness, what does that make me?
Not so good.
A not so good witness, right? Okay. What if I was turned this way and the crime happened over here? What would that make me? Right? What if I was a little bit further back? What would that make me? An even worse witness, right? And that is your job to evaluate those things. It's also not your job to give the government a break. It's almost like they're setting you up like, well, what if we don't have this? What if we don't have that? What if we don't have the 3 or 4 things that you're looking for? Could you still find for us? The legal answer is yes. But is there reasonable doubt in those situations? Heck yes.
Judge, I'm gonna check this is improper.
All right, that'll be overruled.
The answer is heck yes. That's your job. Right? Your job is to evaluate these witnesses for quality, right? For perception, for memory, for consistency. That is your job. Don't let them take that job away. Anybody here believe that this burden that we've established with the government is way too high? Anybody believe because of the nature of the crime that maybe we shouldn't require such a high burden? Right, because I think some of the things he was speaking about kind of diminished levels of proof. You know, what if there's only one witness? Well, what would make that better?
Judge, I'm gonna object to the argumentative at this point. It's improper for purposes of the jurors.
All right, that'll be sustained.
Let me offer you another example using their their photograph. So we saw the picture of the dog. We saw the picture of the trash. Okay. And a lot of us said we've been through that. We know who did it, right? Are there other possibilities of what could have happened?
Yes.
And what are those possibilities? What's that?
The trash could have just fell.
Okay, what else?
Could be a different perspective. Not look at the whole situation.
Okay. What it changes things, right? What if the patio door was open? Does that change things?
Yeah.
Okay. What if there was a cat in the house? Does that change things? Cats are too smart to get caught. That's what that is. Right? What else could change that situation? No dog in there. Right? What about a toddler? Right? Kind of helping himself to the bag to help the dog. Right? There's a bunch of different scenarios. And the reason we're here, ladies and gentlemen, is not because we have perfect cases and perfect defenses. The reason we're here is because you guys are going to decide which way to go with imperfect facts and an imperfect system. What we need to know from you is whether you guys are willing to follow the law, whether you guys are willing to hold them to their standards, to their burdens of proof, right? Whether you guys are willing to understand and accept that if there is a high level of proof put on by you, whether it be preponderance, whether it be a clear convincing evidence, right? Think of it as a wheelbarrow. They're carrying this evidence up the hill. And they've got some evidence. And they've gone a large part of the way up the hill. But it's not beyond a reasonable doubt. What must your verdict be?
Not guilty.
Not guilty. Right? Not guilty. With respect to the question of victims, I was a little bit upset about the number of people who had to deal with this issue. I got people in my family, people that I'm close to that had to deal with that issue, and it's upsetting. And this goes back to the Willie Nelson question. I'm going to ask you row by row. Of those people that raised their hand, that's either they were a victim or they knew a victim of a sex crime. Is that going to affect how you judge this case? How you view this case? Does it make you one bias one way or the other? Number 6. Explain to me a little bit what you mean by that. Okay. And you don't believe you could be a fair juror in this situation? Anybody in the next room? You don't have to talk about your personal experience.
I just feel like it's
Okay. I mean, it's serious, we're here.
yeah, but because if it's the burden of the so like this, this kind of condition, you know, the also.
So you were saying that you cannot be
I
fair.
feel like I have to, it's a trick.
Because I have to get you to commit to this. If this is a situation that would maybe make you be unfair in this particular kind of case.
In this particular kind of case, yes, I have to.
Anybody else? Let's see. Anybody in this row here? Second row. Yes, ma'am. What number are you? Again, the same line of questions. Is this the type of case where you think you cannot be fair?
I'm not certain I do know events in our past affect the choices that we make. I do a lot of these things. And I don't know.
Okay, so unfortunately, I'm gonna have to get you to commit. This is one of those commitment questions that we can ask. Can you be fair in this type of case? Now, again, you may get chosen next month and it's a robbery case. That's me, that's my case. In this case, can you be fair? And you're 28? Number 23.
All right, just a moment. So everyone who's raising your card, here's the question. If you were selected on this jury, having your personal experiences that you've had, would you be able to base whatever decision you come to in this case based upon the evidence that's presented to you? That's the question. Defense, you may continue.
The answer is still no. Okay, the next row. This row here, number 34. You cannot be fair, sir. Next row. Number 38. You cannot be fair.
All right, so everybody needs to speak up, and everyone, if you're not in this box, if you're not on this row, you need to stand. The court reporter cannot hear if you don't stand and speak. The court reporter cannot hear head shakes. It is either needs to be a yes or no.
Number 38 set up, your answer was no? Okay, and so if the court tells you, look, in this case, you need to set those feelings aside, could you set those feelings aside? Number 47?
Likewise, what he said, sir, because of the nature of it, anything that's sexual,
You don't think you can be fair?
I'm pretty biased about that.
Okay, number 54?
So like, if it was like, anything sexual to me, I feel like, I'm saying guilty. I don't know a lot of people.
By the way, this does not automatically accuse you from the panel. This is just, just asking about. All right, this first row here, number 58, ma'am, you cannot be impartial in this type of case. You sure about it? Next row, number 61. Man, you cannot be impartial in this case. Okay. And next row, number 68. You'd already mentioned that you could, one of the previous questions, right? Yes. So the question is that in this type of case, now that we know it involved in sexual assault, could you be impartial, or does your prior experience affect you in such a way that you cannot be impartial? You can be. Very good.
If I can hear.
So maybe you could mention it again. There was some sort of system that you said potentially.
So Bluetooth, I'm surprised it's Bear County, why isn't it Bluetooth?
You're lucky I was able to turn that thing on, so I'll find somebody that knows when to do it. Next row. Last row. Now, Mr. Villarreal spoke about an issue of things that may cloud a witness's perceptions, right? Potentially alcohol. Would somebody that is intoxicated, do you believe that that would be something that you should consider as a witness? Yeah, and I guess let me compare it this way. A person is completely sober versus completely intoxicated. Who might be the more credible witness in that case? Is anybody here that does not drink? Ten, 11, 12, 23, 31, 39, 47, 53, 68, 61, 71, 72, 75. Let me ask you a better question. Is there anybody here that has never been under the influence of an alcoholic beverage? 10, 11, 12, 39, 28, 68, 61, 75. The fact that you have never been under the influence, would you believe that an expert might give you a better perception of what it's like to be? You know, you've never experienced it yourself, right? Okay. And so you have to rely on the word of who? Yeah, potentially witness. Have you observed somebody that is intoxicated? You never observed. Is there anybody here that's never observed somebody who was intoxicated. Number 11. All right, so there's a couple of questions within your questionnaire that ask you whether you had any relatives. I think there's a police officer here, right? Did he show up? Very important business. Is there anybody here that has law enforcement relationships and believe that might affect their ability to judge somebody? 33, 40, 48. I don't believe that this case is going to hinge on the testimony of an officer. But is there somebody here that's so biased for law enforcement that they could not be a fair and impartial juror? Number 33. Explain that a little bit. Go ahead, stand up and explain that.
My daughter's in law enforcement office
Okay,
in the court system.
okay. Here in Bear County? Okay. And you believe that would make you biased in favor of law enforcement?
Pretty much, yeah.
Okay. And do you think that you could set those feelings aside and be impartial, or is that something you can't overcome?
Pretty hard to overcome.
Okay. But can you overcome it is the question.
I really don't know.
All right, if I make you commit right now. Could you set those biases aside if that's what the law required? Okay, thank you for being honest. What was your number, sir?
33.
Anybody else who raised their cards? Number 48. What's your relationship with law enforcement?
My uncle, the police officer.
Okay. Do you think that relationship would cause you to be biased in this particular situation?
Sorry.
Okay, is that not something that you could set aside that the law required you to? What number are you, sir?
48.
And somebody else, number 40. Go ahead, stand up, sir. What's your relationship with law enforcement?
So I'm a judge advocate in the Army, previously in the Air Force.
Okay.
And in that role, I've been a sexual assault prosecutor and also a victim's. Well, I think I could be impartial.
Okay. So you yourself believe you can be impartial. What number were you, sir?
40,
You believe you can be impartial,
I do.
but you believe your experience and job might affect the whole perception of this thing.
I think an outside observer would question, my prior occupations involved in sexual assault trials.
Okay.
And whether I might sway the independence of the jurors.
Sure. Gotcha. Thank you for your honesty. So I think Mr. Villegas also spoke about when we were talking about witness credibility, witness reliability, consistency. Okay. So there are different reasons why somebody may give consistent or inconsistent statement. But does that mean that just because they're inconsistent, we should listen to them? Right? Because it's a legal process and, we should cut them a break because of the type of case it is. Anybody believe that all of these standards that we talked about, including how we judge witnesses, anybody believe that in this type of case, we should be a little bit more forgiving? We should lower our standards a little bit. Anybody on this side of the room? And why not is a real important question. Why shouldn't we lower our standards?
Because of the punishment.
Because of the punishment, right? Because the seriousness of the accusation. Yes, sir.
You held that standard to one, you have to hold that standard to everyone.
Not just everybody, but every type of crime. Right? Do we lower it for murders? For thefts? No, someone's already made that decision for us. It's got to be consistent with everybody. Anybody on this side? Believe that we should, yes.
So. The question is, what happens in this? Right, obviously, we now have a society that. When somebody makes a declaration, you take it for what it's worth, right? You accept it as true. We are now in a different part of the process. Right. If they're inconsistent throughout their testimony, it's not just about the consistency, but it's some of the other standards you spoke about. Do you believe they should be lowered just because it is a sexual assault? Yes. It's hard to talk about different situations, right? Without giving you facts, but I try to talk about generalities. In general, does the sexual assault burden need to be lowered for the prosecution just because it is a sexual assault? Okay, so you give them a little bit of break. Different. You'll be on a reasonable doubt? Burden of proof, that they have the entire burden of proof? Reason.
Yes, typically most sexual abusers get off. It's like it's just mad. It's basic math.
But you believe that the standards should be removed? With all these different rights and burdens that we talked about because of the sexual assault.
Yeah.
And if the law requires you to judge somebody as if it were any type of crime, you couldn't do that?
I could, because it's not up to me to decide what the law is. I'm just saying what it should be, but I'm not saying what it is.
I got you. So you disagree with the law, but you're going to follow it.
Yeah.
Anybody else? If you were chosen to be on this panel, you're not gonna make a decision by yourself. There's gonna be other people in the room with you. And the one commitment I will ask of you is that each one of you walked in here with an individual thought, individual life experience, right? And I would ask you not to allow yourself to be bullied into a decision that you don't want to make. Okay, the stakes are way too high. The consequences are just way too high. The reason that you're here is very, very, very important, and your opinion matters. What we're trying to do with Mr. Villarreal and I is we're not trying to get you into a jury. We're just trying to exclude those people that for sure can tell us this is not my kind of case. Right? Bring me in for a robbery, a car theft, whatever, not this one. Okay. So last chance, anybody have any doubts about this kind of case that hasn't already raised their hand? Very good. Now, with respect to punishment, I'm going to take Mr. Villarreal's example, and Mr. Villarreal said, I go to this restaurant every Saturday and I get the menu, but in reality, I already know what I'm going to do. That's actually not the way you're supposed to do it in this case. Right? You can't tell me that you're going to consider probation if in your mind you're like, I'm not really going to consider it. No, I have to, but I'm just, it's like the menu. I'm just going to look at it and then order my kung pao chicken. Right? Is there anybody here that cannot consider the full range of punishment? And that means from probation all the way up to 20 years in prison for this type of crime. Anybody here that cannot consider that? Number 68. Okay. I think you already answered that question before. Number 20. Okay. And number 48.
I have a question.
Yes, sir. Go ahead.
So that would imply that I wouldn't be able to consider probation, correct?
Correct. Okay.
number 56. You're telling us that you cannot consider probation in this kind of case. Okay, thank you for your honesty. Yes, sir. Anybody on this row? Back here? Anybody on this side, number 4? Saying you cannot consider probation. If somebody's found guilty. Thank you for your honesty. Number 47, yes, sir.
No probation, right, Counsel?
That's the question. Is can you consider probation in this type of case?
No, sir.
Once somebody is found guilty, you don't believe in probation.
In this case, yeah.
Okay. And 34, same thing?
Yes, sir.
Okay. Very good. So I'm going to go back to another example that Mr. Villarreal used, and that is the
8
example.
minutes.
I'm sorry, Your Honor?
8 minutes.
Yes, Judge. That's the example of the parade, right? That, would you expect somebody to remember every single float, every single participant during a parade? And I ask you this, what's the difference between a parade and today's process?
Most serious, like,
It's a little more serious, right?
Okay, so time out. Everyone, if you're not in this box, if you're not on this front row, please stand. The court reporter can't hear. And if the court reporter doesn't take it down, it didn't happen. And
Go ahead, sir.
everyone, please speak up so the court reporter can hear.
like, here is most serious than a parade. Why they ain't really paying attention to everything on a parade, but right here, like, you dealing with somebody.
Okay. Very good. Thank you, sir. Did you raise your? Okay. You have an opinion on that? Number 12? Okay. Readjust your number. It's like an auction. You brought it. Yes, ma'am. A little bit, right? But it's a little bit different, right? But what I'm saying is that the example may not have been a good example. Because what happened is a little more serious, if it happened. Whether it happened or not is a little more serious. And the consequences of what happened is a little bit more serious. Everybody agree on that? All right, number 12. You've been on the option. Do you have any questions of myself? Do you understand the whole process, everything you spoke about? And forgive me, I was jumping around and lost track of my slide somewhere along the way. Anybody in the first row have questions of me or anything that we explained? Second row. Next row. This next row. This row over here. Over after this. Next row. Next row. Switch this side, first row. Any questions? Any concept that you did not understand that you'd like explained better? Second row. Third row. Fourth row. Last row. Who believes that it is your job to solve this case? Whose job is it?
Your job. It's your job.
Not my job. Whose job is it to solve this case?
Lisa.
The state's job. Okay, and who is the state in this case? Michael, there you go. Would you guys be upset if you had to leave this room at the end of this trial and you guys did not solve this case? Well, because that's not your job, right? Your job is, as the judge is going to give you the instructions, to listen to the evidence, to evaluate the witnesses, to use the legal standards that we've given you, of asking yourself, did they prove this case beyond a reasonable doubt? Right? Not did I solve this, not, oh my God, who did this? Not, oh shoot, there's no conclusion to this. for you that is your job. That's all we're gonna ask you to do. If there's no other questions, I thank you for your time.
All right, ladies and gentlemen, I'm gonna ask you to step outside. Make sure that you remain in the hallway, and I'm gonna need you to take all of your items with you, but leave the numbered cards behind. So if you will wait outside in the hallway, and we will call you back in at 2:20. Everyone, please rise.
Yeah.
Right, so we are back on the record outside the presence.
of the jurors. And both parties have given me their agreements. And my understanding, these are the following jurors who are not going to be a part of the panel. 4, 6, 16, 23, 29, 30, 33, 34, 38, 47, 48, 49, 52, 54, 55, 56, 58, 61, 65, 66, 68, and number 73. Is that correct, State?
She lost me. I know, it's hard when you put the other ones that weren't,
Yeah.
that didn't show up. and probably died.
All right.
Okay.
All right, I'll go through it again.
Can you give us the ones that didn't show up?
16, 29, 30, 49, 55, 65, and 73.
Okay.
All right. So does everyone agree to that? State,
That appears to be correct, Richard.
defense,
Yes, Your Honor, those are the no-shows. Yes.
and the ones that you all have agreed to that I called off?
Yes, Your Honor.
All right, so then the next issue is defense. There are two that you're asking to be excused for cause, number 6 and number 9. What is your objection to number 6?
6 we agreed to, Judge.
Yeah, we agree to that. It's actually 9 and 28, Judge.
All right, thank you. Number 9, what is your objection to number 9?
Your Honor, I have multiple objections. One I note is that she, after multiple questions, acknowledged that she was a victim. Also acknowledged that she could not set those feelings aside and be impartial juror in this type of case. And that's the same argument from the team.
All right, well, we're going to take one at a time. So defense, I'm sorry, State, with regards to number 9.
What I recall as far as the victim bias is concerned, Judge, is it said it would be a trigger in her head. Not that she said that she could be fair and impartial. That's what I had written down. Because kept going back and forth, but never been. From my notes and my memory, I don't believe it was rose level. I cannot be very impartial. Rather, it would be a trigger in my head.
All right, with regards to number 9, the court will grant the defense's request to strike that juror for cause. And then with 28, defense, what is your objection to 28?
Yeah, juror number 28 is Kimberly Jacobs. She also responded that she had been a previous victim of a sexual assault and that she could not be biased. I'm sorry, she could not be impartial in this case after multiple questions whether she could set those feelings aside. She stated that she could not set those feelings.
State.
And Judge, my notes reflect that said that not certain that she could be fair and impartial. And so based on that response, my recollection of the notes, I have level.
All right, defense's request to strike juror number 28 for cause is granted.
And Judge, I know that we didn't previously discuss this, but I'm now reminded juror number 36 is a travel constraint. He is flying to New Orleans on
Friday, yes.
And so based on his unavailability, we ask that he be stricken as he would not be able to be present tomorrow.
Defense.
Yeah, Your Honor, we do not agree with that. That's not agreed upon.
All right, that'll be denied. All right, is there anything else?
Yeah, based on that, we have a few more minutes to reevaluate my parameters. We'll submit those.
No, I need to give you your strike zone.
Oh.
Mhm. And Deputy Laura,
So when it makes this jury. Not using my strike.
all right, so let me see where we are. Oh, and I'm sorry, counsel, just so we can have it on the record, your client is using an interpreter, but that's because of the seriousness of the case.
That's correct, Your Honor.
And have you been able to communicate with him in Spanish?
I have, Your Honor.
All right. And do you speak Spanish fluently?
I do, Your Honor.
All right, thank you. All right, let me see where we are. Just one second. I forgot to cross these off. So I put us at 43. Does everyone have that?
Judge, I'm not quite there yet.
Okay.
A moment.
All right, thank you. All right. Oh, well, you know what will take that out? The Tide stick. Yes, that will take it right out. All right, you too.
What number did you say, Judge?
43.
That's what I got, Judge.
Probably messing it up. I don't know.
No. All right, and then your alternates are going to be between 44 and number 50. And each one of you will get an extra strike between those four jurors, 44, 45, 46, and number 50.
Judge, how many alternates are we getting?
We're doing 2.
Do we need 3 since 36 won't be here tomorrow? Or Friday?
We are only picking 2 alternates. All right, and you all may complete your strikes.
Judge, we'll be back in just a minute.
All right, thank you.
Yeah.
All right.
Can you give us a small list? Give us all.
Yeah, she gave us.
Oh, okay.
Yeah.
All right, so we have a new interpreter. If you could raise your hand for me, please. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, if you could state your name for the record.
Norma Nero.
All right, thank you.
You were.
All right, so the court has been given the list of jurors who will be on this panel. Number 3, number 8, 12, 15, 19, 21, 22, 26, 35, 37. I'm sorry, 40 and 41. Any objections?
None from the state judge.
Defense?
None for the defense, Your Honor.
All right, and the 2 alternates are 44 and 50. Any objections, state?
No, Your Honor.
Any objections, defense?
No, Your Honor.
All right, so I'm gonna have the jurors brought back in, but for tomorrow, purposes of tomorrow, state, if we begin at 11, how long do you expect your first witness? Will you be able to get them done in time for lunch?
Direct examination?
Yes.
Yeah.
Okay,
I anticipate, yes. I don't know how.
so is this considered a short witness or a long
My
witness?
first one is gonna be a long,
Okay,
or one of our longer ones.
all right. So we'll start tomorrow with testimony at 11 then.
Just so I'm aware of what we're gonna do, like. Arraignment, you know. Interview, plea, and then opening, all that.
Yes.
Right?
Yes. All right, you can bring them in.
The key just went all the way to the edge. You don't hear people. Have a few, just went all the way to the edge. It's just anywhere. Yeah. But not on me, maybe. Thanks for this patience. That's like the airplane. All the way to the end. They try. Yeah. They don't have to sit in the same spot.
Okay.
Not anymore. All the way to the edge. To make it easier for everybody when they walk in. The last row is over. It'll be easier for people, because not everybody can get a chair. They can sit. All the way to the end. Just anyone else. There's some in the back row. If you don't have anything, come on over. First stitch right here. Dun, dun, dun.
That's not a good sign. I don't want to.
Just no, you can't. Up there, they're gonna be selected. So this bench, you can sit right here on the bench. Oh, they're not assigned anymore. Yes, sir. Not everybody's gonna be in the chair. And that's it.
All right, everyone, please be seated. All right. What I'm going to do is I'm going to call the names of the people who will be on the jury, and when I call your name, you will take a seat in the box to my left. Thank you all for coming in. We cannot have jury trials unless we have jurors. You will be receiving a white sheet of paper from, I believe, Deputy Mejia. do not leave without receiving that. That will signify that you are here today. And also, it will see that you are paid for your time here. You can accept your payment. It'll come through the mail, or either you can donate it. There are plenty of organizations to donate it to if you so choose to do that. You'll need to go down to the central jury room to get your parking validated. So I'm going to call the names of the persons who are to be in the box. Lisa Garza. Quincy Floyd. Cipriano Beltran. Taylor Luster. Markel Stevenson. Carlos Lopez. Janet Lafashi. Carlos Miranda. Martha Hernandez. Ana Trevino. Joshua Bates. Michael Carmine. Nicholas Knox. William O'Toole. All right, the rest of you are excused.
Just like that, yeah.
I'm aging myself. A couple of weeks ago, I had a patient, his name was Dan Cook.
Really? So I know the agent.
Is it two, and then the ring shirts, the beard, and the man bun?
People always want to stay.
That's continuing, because they went through first council. Mental health work.
All right, everyone, you can be seated.
Always.
All right, so I'm going to tell you all the way things are going to go, the plan. We're going to meet back here tomorrow at 11. And at 11, you will be sworn in. And the state and the defense will, if they choose, get a chance to do opening statements. And then the state will begin their case in chief. I'm going to swear you in tomorrow. This courtroom, it's a new courtroom for us. So bring a jacket in case it's cold in here, because I have no control over the thermostat. So it's better to have a jacket and not need it than to need it and not have it. I know that the chairs may be uncomfortable. There are pillows in the back. You can bring those out each day with you and put them in your chairs. The reason why we're starting at 11 is because I still have a docket to run in the morning. So I still have lots of cases that come in. And so we're going to be back at 11. Now, the parking garage. Everybody who works in this building parks at the parking garage. The powers that be that decide to put up the parking garage, I don't think they counted well. So if you come at 11, there may or may not be space available for you there. If you come early in the morning, because everyone is here usually by 9, if you're here at 8:30, there's a jury room that Deputy Laura will show you. So you can come at that time and then you can enjoy the Riverwalk till we start at 11. And you're allowed to bring, if you want to bring lunch, you can bring lunch. There's a refrigerator there. If you want to bring breakfast, you can bring breakfast. During our breaks, for lunch break, which I will give you your lunch break. You can also walk around. There are different places downtown where you can eat. There's also a cafeteria downstairs in the basement if you so choose. Any questions about anything so far? All right, so when you report here to court, you will not report inside the courtroom. Deputy Laura is going to show you where you report, and that's going to be the jury room. And then the thing about being here at 11, we can't start unless you're all here at the same time. And I will immediately cut off docket tomorrow so we can start at 11. I don't expect any publicity in regards to this case. But if you see something, if you hear something, if you see something on television, do not investigate, do not look at it, turn it off. If somebody tries to talk to you about this case, tell them you're not allowed to. Don't do any of that. Everything that you need to know about this case to make a decision will come from inside this courtroom. Does everyone understand? All right. So does anyone have any questions before I release you? Yes.
Said 8:11, we're supposed to be here?
You're supposed to be here by 11, but because the parking garage gets filled up, because everybody who works here parks at the parking garage, it's probably best for you to be here at maybe 8:30. Yes.
Stupid question. Obviously, you guys aren't doing this on the weekends.
No, but I will tell you, there have been, yeah, he's like, don't tempt me. There have been judges who have had people on Saturdays, but I don't do that.
Outstanding, especially next weekend. Perfect.
Okay, all right. Yes.
I know that this is just an ish, but I have to reschedule patients. So like how long-ish, how far out should I move them to stay here?
Well, jury trials sometimes can take a life of their own, but my understanding is that this case may be completed by Friday. Friday or Monday.
Okay, thank you.
But I will tell you this, we're going to go all day Friday. So we're going to start early on Friday at 9 and go probably to the end. So that's why when they say, we think Monday,
Sure.
we're looking at Friday.
Sure, it's 2 to stay. It's a good time to schedule.
Oh, okay. Well, I think you may need to talk to them about that. Yes. Any other questions?
It's no longer valid because it's gonna go farther.
Yes.
Yeah. Yes. Anything else from anyone? All right. So Deputy Laura then is going to take you to the jury room and show you where you need to report. Oh, and I forgot to tell you all, you can bring drinks in the courtroom. Just make sure there's a cap on it so there's no spillage. All right. Thank you.
ma'am.
You're welcome.
Bro, I told you.